One matter 2016 matter. This, while admitting this case, this court has made it rule returnable within 6 weeks. 6 months. Now it was running in the list for weeks together, for several weeks it has come. But all of a sudden, the order was passed that let it be in usual course.
Who has passed it?
The Honorable Judge.
Which judge?
October 24.
So you filed a petition
I
for
filed
fixing a date?
I filed a IE petition for that, for fixing the date of early hearing. The IE is our appointment.
It will come after the hearing.
Two old rate petitions, Your Lordship, I was only praying for this thing.
Consent
2003 and 2008 matters.
ये जितने matters हैं ना इनके opening day लगा दे?
हाँ जब
15 तारीख. You have kindly inform the other side also.
Yes.
2003 का matter आएगा तो is likely. कल लगा दे?
कल नहीं.
कल नहीं.
Other side might talk.
कल थोड़ा सा दिक्कत है. नहीं कल इसलिए लगाएंगे कि अदर साइड को नोटिस हो जाए.
ठीक है.
और कोई पर्पस नहीं.
Yes yes.
कल थोड़ा सा मुश्किल लग रहा है ओपनिंग.
जैसा जो whatever is convenient.
नहीं अब 15-10. 15-10 खुल रहा है ना? कब? 14 को. नहीं 15-10 को सप्लीमेंट्री में लगाएंगे.
हाँ एक दिन ठीक है.
My case will have like
आपका आ जाएगा. आइए तो ऑर्डर्स नहीं आता है.
From supplementary list for judgment, item 1, MA 279 of 2016 along with section 2.
MA number 279 of 16. Is disposed of with enhancement of quantum. I've given the calculation chart, and MA number 279. MA number 639 of 2016, which has been filed by the state, is dismissed. ये जो है ना, इनको बोलिएगा थोड़ा बोल्ड कर देना. एक लाइन जो है ना, बोल्ड नहीं रहने से खोजने में दिक्कत. पैरा 9 में, ना, MA number 639 of 2016 is dismissed. इसको थोड़ा बोल्ड कर देना. बाकी पेजेस में हम साइन कर दे रहे हैं. उसको आपका है ये. उनको ये पेज भेजिए, पहले इसको बोल्ड करके भेजेंगे. इसको हम साइन करेंगे. I have considered the judgments and then I have considered 2016 judgment that was specific rule, and then I have considered that some question in two judgments.
And regarding ex gratia, I may be allowed to go.
You can go through, but that एक पेज थोड़ा सा बोल्ड कर
नहीं वो अलग से
आप देख वैसे तुरंत ही अपलोड हो जाएगा 10 मिनट के अंदर अपलोड हो जाएगा
D. From daily list, running for judgment item 1 ME 195 of 2020.
You are for whom? Insurance company?
Yes.
I have held that for 163 capital A, future profits will not be. Stop looking.
From supplementary list for orders item 3. WTC 5844 of 2020.
Name of respondent number 3, Mr. Rakesh Paswan, name was missing in order on order dated 18/7/2024.
WPC number 5844 of 2011. The matter has been listed. On mentioning by the petitioner, he has pointed out the name of the counsel for responding number
3.
3. Who called?
वो ठीक है स्टेट
Respondent
ऑफिसर
number 3 has neither been incorporated in the cost item of the disposal order dated 18/7/2024. कोई appeal हुआ?
नहीं कोई एपीआर नहीं हुआ तो नोटिस हुआ वैलिड सर्विस हुआ था
He has submitted that nobody had appeared on behalf of the state respondent number 3 in spite of service of notice. He submits that the order dated 18/7/24 counsel for the respondent number 1 and 2 has no objection to the player made. Considering the submissions, the cost title of order dated 18/7/2024 is hereby modified as follows. Respondent number 3 का नाम ऐड करेंगे वो ना असल में मेन पेज के लेफ्ट हैंड साइड में था इसीलिए ठीक है उसको ऐड करेंगे और रिस्पॉन्डेंट नंबर 3 को नन करेंगे और रिस्पॉन्डेंट नंबर 1 जहाँ लिखा हुआ है 1 and 2 करेंगे ठीक है the learned counsel for the respondent number 1 and 2 has also submitted that he was appearing for both the respondents 1 and 2 but his appearance is only reflecting for respondent number 1. He submits that the order be accordingly modified. This the order dated 18/7/24 is accordingly modified. Office को बोल रहे थे correction करना. Office is directed to carry out the necessary correction. कैसे होगा? का कितना बड़ा नाम है?
राकेश पासवान
छोटा ही सा है, हो जाएगा। to carry out. सबसे तो कॉस्ट टाइटल जो है रिस्पॉन्ड नंबर 3 डालेंगे, जहाँ पे मिस्टर राहुल नामा का रिस्पॉन्ड नंबर 1 है वहाँ 1 इंक्लूड करेंगे, ठीक है। रिस्पॉन्ड नंबर 3 की तरफ से नन लिखेंगे।
Item 4, there will be filing number 9545 of 2024.
Why is it listed with filing number? Sorry,
कन्वर्ट कर
क्या चीज़ कन्वर्ट करने का?
लेबर कोड का है एमए फाइल
MA फाइल। They have officers pointed out such defect. Workman compensation with the MA file. WPC number 9545 of 2024. The learned counsel for the petitioner has submitted that officer pointed out the defect in this case on the point of maintainability of the petition, as he submits that miscellaneous appeal is maintainable against the improved order passed under Employees Compensation Act 2023. It submits that appropriate order be passed so that the petition be modified by the petitioner. Considering the opposite submissions, the counsel for the petitioner is permitted to carry out necessary corrections in this petition so as to convert this petition into a miscellaneous appeal. The needful be done by 18th of October. Thereupon, the office is directed to carry out fresh stamp approval and procedure. अपना नाम बताएं, what's your name? Repeat again.
For Remission item 5, WPC 2623 of 2021.
Yes.
This is a matter pertaining to NHI acquisition. Kindly have their order, last order 9th September.
Yes.
6 weeks are not over yet.
So therefore, let the
Next meeting is on 7th.
I filed an IA annexing one document issued by the SDO concerned, wherein the DCs after due meeting with the SDO and CO concerned, they have issued a direction appointing Kedar Mehto as a Kanya Benta for monitoring the demolition of the concerned place. That therefore they will give a task force for that also. So since the matter is pertaining to whether clarity is not there, so
Is it situated with what is the description? Is it covered by LA case number 19 or 9?
No,
29.
no, it is not there. So only the thing is in this matter, the NHI has already constructed the 4 lane. Now it is a matter of concern for there to make a drainage out of in the service lane. My service lane, their service lane, my Dharamkata ancestral business is there. My home is also located there. Since the acquisition has taken place in the other side of the road, what happens in this matter is The center line has been shifted for 5
You
feet.
just filed 1 day back.
No, apart from that, one IA is previously also pending.
No, you respond. You
Yes,
do the
we'll
needful,
file.
and please don't disturb people like that.
We will file that tonight.
In NHI matters, we are not going to pass any order, but you just ensure.
Yes.
Your Lordship, the petitioner is claiming 10 plots of the land, Your Lordship, of the 2 different khata, Your Lordship.
Okay.
6 plots are acquired, Your Lordship. The compensation has paid, Your Lordship. The affidavit has filed by the executive engineer, Your Lordship.
Compensation for the acquired land has
Yes,
been
Your
paid to the
Lordship. In the
petitioner.
year 61, 62, Your Lordship.
Let's, I'll just clarify.
Can you see?
I'll just clarify. I will
No,
not claim
no,
anything.
no,
No.
no.
Let's-
You
Only
see-
one thing. Let's.
On the just we are on the verge of vacation. Today we are not going to. They may respond to your IA. You have just filed it 1 day back.
Only one allow.
They have right. They have right to
It is
respond
there,
to your
it is
IA.
there.
Let them respond.
Only allow me to only place one factor.
Nothing. Nothing is going
It
to
is there in the
crystallize.
counter affidavit. Kindly appreciate.
Nothing is going to crystallize because they need to file a response to the IA. Just 1 day back you have filed
Both
that
of them
IA.
have filed the counter affidavit. What beyond that counter
We are
affidavit?
not here for final disposal of
There's
this
only
matter.
one request. Since
No,
they
this is a voluminous file. It requires a
they are
in-depth
about to
matter
demolish
of-
that Dharamkata business, but the ancestors' business is there since ages is there. Only indication is this: the counter affidavit para 11 may be seen. The NS division should be made a party to this matter as the state government has filed an IA which has been discussed in previous occasion. Kindly see the supplementary affidavit para 11, May 2024. Supplementary affidavit of
When was the
response.
notice issued to you? When was the notice issued to you?
This is a recent notice given.
When? What is the latest cause of action?
Latest cause of action for which I have filed an IA, that's the day before 25/9, 25th September. And immediately after I filed an IA placing this document, but then one IA has already been pending here.
No, where is the notice? What is the latest action?
IA number 10867, page 8. IA number 10867, page 8. At one hand, they want to file a response to this and they are issuing this notice. 10867, page 8. And NHI has already made a requisition on the basis of which they have initiated this document.
You want a stay on which property?
The property which is
You just give the description.
description
of
is there in the order sheet itself.
Let us see.
Leadership may have the order
Let us
dated.
see the description of property.
I'll just give. Leadership meanwhile leadership may have 18th March 2024. The description is there in the order sheet itself. 18 March 2024. And these have never been acquired. I have already annexed the
We
document
will
also.
just fix it like that. 18th March.
18 March.
Okay. Yes, madam. Have you got the order? Copy of the order? 18th March. Which property you have said that it was acquired and the compensation has been given?
Can you see the affidavit filed by the state, Your Lordship?
Yes.
Filed on 3rd May 2024, Your Lordship.
Yes. Of the state.
Yes, by the state, Your Lordship. And the page annexure G, Your Lordship, and page 22, Your Lordship. There is the description, Your Lordship, for which, about the land, Your Lordship, for which the compensation has paid, Your Lordship. And the 6 plots of the petitioner.
Tell us where are these 3 plots? You show us khata number, plot number.
Khata number is not mentioned, Your Lordship, but the plot numbers are mentioned.
Yes, tell us the plot
The
number.
first plot is 5171,
Where is it? Page number 22.
22 first, column first one. And then the 5174.
5171. Just let us match. 5171 is there.
Yes.
Okay.
And
Then
5174,
5174.
74,
5174, yes.
5175,
75, yes, 75, 76,
76 is also.
77.
Yes, Lordship. And the 6.
Yes, which is that plot which is left
Kindly
out?
see the same page 23. Page 23.
Which is that plot which is not matching?
So these
the
are
description of
5193.
property?
Page 23 refer to 5193, 5194.
Yes.
अभिलेख उक्त प्लॉट का उल्लेख नहीं है.
That
So those are the documents.
That
Just a moment. 5193 and 519.
Yes.
Only these two
No, no.
blocks.
I am just only.
You can have a stay only in connection with these two blocks.
The entire plots are big enough.
We
I
do
am not
not.
from the family.
You
I'm
see,
not.
we don't bother about
The
it.
517
You
is
just tell
from
us, you
Beacon
cannot have
Rana.
a blanket stay like that.
No, I'm not asking for a blanket stay.
Then
Just
what?
only one indication is.
No.
Be it a shorter date only.
No, what shorter date?
I'm only
Where is the
saying.
shortest date?
Meanwhile, they file a response. They
They-
should not interfere with the
No,
property.
no, no. It is not so simple.
See, Beacon Rana is one.
You see, you have given the description of property.
Yes.
They have annexed a document by saying that these properties were acquired and compensation paid. They have, with respect to two plots, they say that the details are not available. I can stay only with respect to those two. Why will I stay for others?
So the difficulty would be, let's kindly appreciate.
There will
The
be lot
plot-
of difficulty. Let them. We will
The
not.
plot are big enough, and I'm that
They
Rajesh.
will measure it. What's the big deal about it?
That will
We
suffice
do not,
my
I
purpose.
will not say anything.
Let's see, that suffice my purpose.
You just tell us, if you want a stay of demolition, you tell us this property is standing in which plot number.
So the claim.
I want to know, it's a huge property, right? You tell us that you want a stay of demolition of a particular property, right? A particular construction on the property. You tell us what is the description of the land on which this structure is standing.
If lady may permit me, for a short pass over, I will give a specific detail on which
You-
property.
We do not.
So therefore, my.
No, your verbal submission will not suffice.
So therefore, from
when
the-
you are seeking a stay, then you should have given the description of the property, description of the land on which this structure is standing.
Just only indication, humble indication. Try to understand. I'm just trying to
No, I'm
project
just trying
myself
to
in a way
understand.
with the idea.
I am trying to give you relief, whatever you
Let's
insisted.
kindly see page 8 for a while. There is no description on that. Rajesh Kete has been given the
We do
notice
not.
for this.
And you'll also.
So that includes the entire. There's
For
only one more thing.
national highway, we are not going to pass it.
Because it is already being functional. It is not in. It's I'm not on making any.
And it's the completion you'll also stage you'll also the project is
You are not in a position to say the description, the boundary of the land on which the description of the land on which the property is situated.
I have annexed the notification of the
Your
state government
notification
itself.
will not serve. You have to say that your house or your shop is standing on such and such land.
Because my claim is over the entire property. Only my indication, Lordship, is see the page 23. The name is referring not from KD Hamlet. This is some Beacon Run and some other person, not for me. So therefore, the entire the NHI has not acquired the property.
No,
NS
no,
division
we
has
are
acquired and then given to the NHI.
Let them file.
So
a
NHI
response.
has
We do not
given-
do. We do not.
Because meanwhile, they should not interfere with the only. Kindly see the IA of page number 8. What they have written in the document. They say the on the structure project page 8. परियोजना निदेशक भारतीय सोइंसो परिवार सोइंसो भारत संख्या सोइंसो हजारीबाग के पत्रांक संख्या सोइंसो 21st September 2024. So it is a recent after the
You
issuance of
just
this
tell
order
us
itself.
one thing. You have pointed out the description of the property involved in this case.
Yes, ma'am.
What answer do you have so far as these payment of these properties which are mentioned here?
So therefore, why there is a problem? Kindly see the same affidavit, page 23, para 11 may be seen. That is the troubling. That is the point which you are troubling. Para 11 may be seen.
Of page number?
Page number is page 8. 8 of the same counter supplementary counter. It says that it stated submitted that records pertaining to the plots in question and original records of alien numbers also did not find mention of any of land acquisition proceeding against the petitioners.
So therefore, you must be having the records of LA case number such and such. You must have verified that it is not mentioning.
This is a counter affidavit, not my record. This is a counter affidavit given by NS division itself.
Okay.
So
It
therefore, that order has been passed by the honorable predecessor court, saying that there is no clarity as such. Giving one RTA reply saying that there is no plot mentioned, अभिलेख में उपलब्ध नहीं है, ऊपर कहते हैं बीजू नाना को पैसा दे दी. So there is a difficulty with para 11. It is their own counter affidavit which has annexed that document. What we need know only thing is that the middle part from where the 75 feet has to be calculated, they have shifted a middle portion of it. Therefore, the entire problem is.
Your Lordship, Annexure 1, Your Lordship, the petitioner has annexed the map, Your Lordship, of the road, Your. And only on the basis of rent receipt, Your Lordship, petitioner sir is claiming title over the land and what?
I'm not claiming over it. It is no matter of title. If they have acquired, I will leave that property. But then the problem is they itself have not clarified here. Parallel 11 shows so. So that is a difficulty. The only problem is one side of people are at peril today because they have shifted the alignment from the middle from where they have to calculate it 75. This is the only issue.
You just tell us
Please.
that what is the property on which this land is standing.
I'll just
This,
indicate.
not indicate, you have to file an affidavit. Call your person.
We'll do
They
that.
need- You file it?
We'll do it. We'll do it.
You file it, you file an affidavit.
We'll do that.
We are here for the whole day, file an affidavit.
We'll do that.
And you annex the sanction plan also.
Sanction of the
It
building
must-
concern.
Of course. Sanction of the building concern, it must have been a sanctioned construction. Right?
We'll ask.
You pass over, you can come
The
throughout
person
the
has to come from Kodarma. So I'll just try to ask him to
You can
leave
come
immediately.
if he wants to stay.
Yes.
From daily list of final disclosure item 2, the LPL 193 of 2015.
Who is for the petitioner? Yes, you are there.
Leadership, praying for short password.
What is the matter?
This is the matter where the employee has been retired.
Who is for the other side? Who is for the other side?
Pardon, Lordship?
This is a transfer, right?
Yes, Lordship.
He's not being paid the post-retirement benefits. Where is your counsel? Who will argue this case?
Lordship, Mr. Shivkumar Sharma, he's stuck in traffic jam, Lordship.
Traffic jam.
Yes, Lordship. So it may be posted after 4 or 5 cases so that he can appear, Lordship.
Second half. Come in second.
Item 3, the UPC 5781 of 2016.
Mr. Rupesh Singh is on legs and report number 7.
No. You just start your one. Let us see what is the matter about. You explain me the matter. You just explain on the point of jurisdiction.
These oil marketing companies had framed a marketing disciplinary guideline which has been challenged by the petitioner. What had happened was these marketing guidelines are basically framed to regulate the ethical and non-ethical practices of the dealers, basically who handle these LPG cylinders or petrol pump. What used to happen that these dealers were not passing the benefits to the ultimate consumers.
What kind of benefit?
For example, what happens? These OMCs have a guideline that you have to give home delivery of the LPG cylinders. So, they were not giving home deliveries. Then, there was a guideline that in case if the customer comes to your outlet and he takes the LPG cylinders,
Some remission.
some rebate has to be given.
That's
And then you have to have all the licenses, like explosive license and other license, displayed in your office of dealership. So, there were n number of things which were to be controlled by these guidelines. So, these guidelines were framed pursuant to a contractual clause. If
Let us see that guideline which is under challenge. Where is it?
may kindly take up 5781 of 2016. If Manoj has that.
5781. Yes, I know.
Annexure 6.
Annexure 6.
Actually, there are two guidelines now. In these matters, broadly, one is of 2001 and one is of 2015. There are two guidelines involved.
Annexure 6. Annexure 5. There is no annexure 6 in the main petition.
Because in the index, they have mentioned. But they have filed annexure 6 by way of a supplementary affidavit. This supplementary is dated November 2017. Page 5 of that supplementary.
Yes. Which clause is that? Clause number?
There are various clauses which regulates, like
So what is it they are challenging?
They are
must-
challenging
the
the entire
entire thing.
guidelines. Entire guidelines.
Very good. Have they specified?
No, Manoj.
Is it their case that the authorities do not have the jurisdiction to frame these guidelines?
That is their case. Their case is that the oil
You argue their case because they are not here to argue.
Manoj.
First you argue their case and then you argue your case. Let me just figure out.
Their main argument is that the oil marketing companies do not have any jurisdiction or authority to pass these guidelines. They are saying that under the Essential Commodities Act, the Essential Commodities Act provides for making control orders. And for the LPGs, there is already a LPG control order. So a parallel marketing disciplinary guidelines cannot be framed, and as far as control order is concerned, that is framed by the delegated legislation. Manoj, the same issue, Manoj, had come up before various honorable high courts, whether the marketing disciplinary guidelines have the oil marketing companies have the authority or not. Manoj, we have given a
yes, you
side.
just refer to the best judgment you have.
Manoj, we have two best judgments. Manoj, one is of the Honorable DP of the Delhi High Court and the Honorable DP of the Karnataka High Court.
This is that serial number?
Serial number A1 and A2, Manoj.
A1 and A2.
Manoj, I would first place Manoj the Delhi High Court judgment. Manoj. The relevant paras are para 37 onwards.
No, we will not read the judgment like that.
Manoj, only the relevant part.
No, just. Let us see what was the issue involved before the court. Was it under challenge?
It was
Directly
under
challenge?
But that question is also framed, Manoj. If Manoj can have para 37 only, Manoj.
Okay, it was struck down by the single judge.
Single judgment. It was struck down.
So it is all the more a reasoned judgment.
Manoj. Then it went to the Honorable Division Bench, Manoj. The Honorable Division Bench upheld the validity. Para 37, Manoj. Of the judgment. I'm being led by Mr. Gupta. If Manoj.
He is doing it fine, yes. Yes.
Keep up.
I'll supplement it with that.
Chal.
Manoj, para 37.
Only thing, Your Lordship, Mr. Rupesh Singh had said, requested for a short pass.
No.
Otherwise,
We will hear him.
Oh,
There is no question of passing an order
Yes.
without hearing him. But these judgments I have not been able to
As-
go
as-
through.
as-
So I just wanted to
I
have
just-
a look.
Yes, he had asked me for that he'll be seeking.
You see, we have made it very
Absolutely,
clear
absolutely.
that if these guidelines are upheld by this court, then there is no question of entering into the contractual dispute.
Absolutely.
They have an alternative remedy of appeal. They have an alternative remedy of arbitration.
There are
But these guidelines, the validity of these guidelines cannot be decided by them.
absolutely.
So Supreme Court will decide that and leave it to them.
Apart from that,
And if we quash these guidelines, then under such circumstances, the remedy is with them. There is no problem.
Once para 37 minutes.
Yes.
Reasons and analysis. If I may please notes.
Yes.
Having heard learned Solicitor General appearing on behalf of the applicants, learned senior counsels appearing on behalf
Sorry,
of
para number
37 minutes.
37.
This is the relevant chapter which deals with validity of
किस कोर्ट में है वो? कोर्ट नंबर
7.
Once para 57, having heard learned Solicitor General appearing on behalf of the applicants, learned senior counsel appearing on behalf of the respondents, and learned senior counsel appearing on behalf of the intervenants, we hereby partly quash and set aside the judgment and order of the learned single judge passed in WPC number 74 dated 18th March on account of facts, reasons, and judicial pronouncement detailed hereinafter.
Why part की citizen?
But what had happened, there was a clause in the MDG guidelines with respect to controlling the washrooms. There, the free permission was granted to the public that anyone can come and use. To that aspect, it said that it might just affect the security of the retail outlet. Therefore, that was modified, and it said that the manager of the outlet will have the ultimate power to permit or not permit it
That's
to somebody. That was
It was not made accessible to public in general.
in general.
those people
where
who are
there is a
commuting,
security threat, the manager of the outlet can refuse.
only to that extent.
Only to that extent. Clause 43 of the dealership agreement. Appellants OMCs entered into a dealership agreement with the ROs, retail outlets. Clause 43 of the dealership agreement reads as under. The dealer undertakes faithfully and promptly to carry out, observe and perform all directions or rules given or not made from time to time by the corporation for the proper carrying on of the dealership of the corporation. The dealer shall scrupulously observe and comply with all laws, rules, regulations and requisitions of the central state government and of all authorities appointed by them or either of them, including in particular the Chief Inspector of Explosives, Government of India and or municipal and or any other local authority with regard to the storage and sale of such petroleum products. So, the first part of clause 43 takes care that the OMC will have the right to make the guidelines. Right from the year 1981-82 to maintain discipline in the operation of retail network of thousands of petrol and diesel retail outlets of OMC oil companies throughout the country, the marketing discipline guidelines (MDG) were formulated and issued. These MDGs have been reviewed from time to time. Clause 42 of the model agreement, which has already been upheld by various high courts, replicates the contents of clause 43 of the dealership agreement in question. By virtue of powers conferred by clause 43, the MDGs have been issued. Thus, this provision is the source of power of the OMCs to formulate the MDGs. Power of the OMCs under the earlier MDGs was subject matter of challenge in several writ petitions in various high courts, including this court, and was upheld, holding that OMCs have the power and jurisdiction to issue MDGs to regulate the retail outlets and that the retail outlet dealers are bound by these guidelines. This court in Delhi Petrol Dealers Association versus Union of India reported in 1999.
That's right, it's very clear. Para 44 is very clear.
Now I'll show same clauses are present in all these matters, same contractual clause. If my lords, I have a short chart where I've given
This clause, this chart.
yes, indeed. In the in this matter, clause 43 is the same, faithful performance clause. This was with the supplementary affidavit, the agreement.
Clause 43.
At page 43, it's not the clause 43, page 43, running page 43.
43?
Of the writ minutes. 5781 of 16.
That contractual part.
Well, contract, which enabled these companies to make guidelines. Running page 43 minutes, the third clause from the top. On the right hand side, minutes would see faithful performance. Faithful performance, because on the right hand side it is written.
Yes, please.
It reads, the distributor undertakes faithfully and promptly to carry out, observe and perform all directions and orders or rules made from time to time by the corporation. As corporations are these OMCs. In this case it is Indian Oil Corporation or its representative for the proper carrying on of the distributorship of the corporation. So these are the contractual clauses which enable us to make these guidelines.
It is a common contractual clause.
Common manner. I have in this chart I have shown where are these clauses, at which page.
This is clause number 42A.
This is in the 3952 of 2011.
this 40, this is 42.
This is this is at serial number 5 in the chart. 5, 7, 8, 1, 26.
The same clause is
in all the matter, in all the cases.
but the clause numbers are different.
Clause numbers.
Okay.
So we have referred the clause numbers and the relevant page where this clause is in the.
आप एक काम करेंगे, you just flag those ऐसे नीचे in all the repetitions.
In all.
आज जो है आपको open invitation है till 4:30, ठीक है? इसीलिए उनको बोलिए जब भी वो आएंगे हम केस करेंगे, लेकिन आज adjourn नहीं, ठीक है? बुला के लेके.
There is also an arbitration clause. Should I
Yes,
flag the
sir. Not required because arbitration clause will come into play only when
Alternative.
all that तो we are aware of. We need to worry about it. वो थोड़ा सारे रिकॉर्ड में इसको फ्लैग कर देंगे, ठीक है? अभी तक वही मैटर चल रहा है. कोई बात. Let him come. We'll hear whenever he comes. We will hear. And you be here. Don't leave the court.
For admission item 8, LPC 583 of 2013.
Yes, petitioner.
Let's, in the last opinion, there was direction to file counter affidavit. Malus counter is ready. Malus.
There is file it.
Malus, in the last opinion, there was direction to Malus that what action has been taken against the
Direction is that there is contradictory stand of the state.
Malus.
On the one hand, there is you say there is connivance, and on the other hand, you say that there is no connivance.
For that, Malus, a direction was issued to the circle officer, Malus, to take action against, to find out the hearing officers, Malus, and after inquiry, Malus.
Circle officer will find out the hearing officer, or you will find out the hearing officer. Circle officer अपने ऊपर inquiry करेंगे क्या?
DC has directed the circle officer to
He
find
will do
out.
the inquiry. Maybe that he is a culprit. Then the inquiry was to be done by the deputy commissioner himself. ऐसे कैसे हो? Passing the ball.
Then I'll seek instruction on that point, Malus, that, or I will suggest.
जब आप ये एफिडेविट फाइल किए तो आपको ये बात स्ट्राइक नहीं किया कि मे बी दैट सर्कल ऑफिसर is culprit. You see, as of now, the court has directed the deputy commissioner to file an affidavit because the court assumed that at least the deputy commissioner would not have any connivance, right? And so far as the conduct of circle officer is
Since
concerned,
in this case, deputy commissioner has passed the impugned order, therefore he cannot continue. The other junior officers,
Yes.
Lordship, the SGO, LRDC, and
That's
the
right.
AC, even the AC. Most role of the AC is there, Lordship, not the circle officer role is also
no,
not there.
this
Since the AC
inquiry
has
was
passed the
required
order.
to be done by the deputy commissioner himself.
Yes.
ये बात deputy commissioner को समझ not able to understand this basic thing. He's asking the person whose conduct is under cloud to conduct an inquiry against himself. Possible? देखिए, an affidavit, a personal affidavit of the deputy commissioner Kotarma has been filed today during the court proceedings, which is taken on record. Criminal case institute कर दिए क्या?
Not yet, Malus.
Have you
Earlier
mentioned
direction
it?
was issued to circle officer to find out the Malus
The
hearing
learned
officer.
counsel for the state has submitted that as per the affidavit.
Just a copy मिला है.
As per the affidavit, the circle officer has been directed to conduct an inquiry to find out the erring person. आप प्राइवेट रिस्पोंडेंट हैं?
नहीं, इनका तो लोकल असिस्टेंट है भी
Workman.
नहीं है। नहीं, इनका लीज भी फरवरी 2024 में खत्म
हमारे
हुआ
instance में सब
है। Yes,
हुआ है,
at the
पता
instance
लगा
of the
है।
private
That's
respondent
what
that
I'm
proceeding
Why
was
they should
initiated
object
lordship,
it?
and there is a judgment of the honorable division bench that there is no provision in the state of Jharkhand for cancellation of Jamabandi lordship.
We'll see.
We have lordship also. I will be giving some judgments on that point.
Just-
When it can be cancelled.
just, considering the nature of dispute involved in the present case, this court is of the view that the matter relates to cancellation of
Cancellation of
Jamabandi.
Jamabandi.
Just a moment. The matter relates to cancellation of Jamabandi, and the circle officer is the person who is a circle officer, and other officers under him. Under him are the persons who are primarily responsible for creation
No,
of.
no, no, this is not the case, lordship. There is no such record.
No,
From
no.
where the impugned order has come, just before that, how it has come by the AC, it is also under challenge.
No,
There is no previous
earlier
order.
Jamabandi was running
Lordship
in
will kindly
the
find
name
out
of
that
vendor of the
complete-
petitioner
complete-
lordship.
Just a moment. Considering the nature of dispute involved in the present case, this court is of the considered view that the matter could not have been left to the circle officer to conduct an inquiry.
Yes.
As the conduct of the circle officer could also be a matter of concern.
Yes, yes. Because since the AC order.
At this, the learned counsel for the state submits that he shall file an appropriate affidavit to that effect. He shall seek instruction and file an appropriate affidavit. Let the appropriate affidavit of the deputy commissioner किसी और का मत फाइल करिएगा.
There is no order.
Be filed by 15th of October, post on 16th.
And the present supplementary affidavit may be kept.
It is kept on.
Ma'am.
It has already been taken on.
Several chances were given to the state lordship to bring all the records, but there is no such record. Only one order of the AC is there. That lordship we have complained with the deputy commissioner, being the
We'll
AC.
hear it on
Yes,
merit.
yes, lordship. Yes.
First, the inquiry cannot be
Yes.
conducted by the circle officer.
Yes, that is-
There cannot be any doubt on
That has to be lordship.
With regard to land records, if there is any problem,
He is the primary person.
he is the primary person. He will conduct an inquiry against himself.
But in this is a unique case, lordship. No role of circle officer is there. AC is directly coming from nowhere.
We'll see which
Yes, lordship.
circle officer will not be the appropriate person.
No other previous orders are there.
Item 9, WPC 4254 of 2017.
I pray for my
WPC number 4254 of 2017. You have further respondent?
Yes, sir.
2017 का matter. Do you have any objection?
I am only praying for no to.
The matter is now settled, madam. There is no.
No, matter has not been settled.
Yes, yes, of course. The prayer is for fixation of rent with respect to the land. And
It has been fixed.
Yes.
No, not fixed lordship. Therefore, I am praying
Show
for.
us that it has been fixed.
Yes, yes. I filed an affidavit to that effect. Madam, you kindly see. There were 10-year holders and the land was purchased. They filed an application for fixation of rent. Now in the year 2016, there has been a new survey settlement operation, and as per the rules of the Encroachment Tenancy Rules, Rule 33, during the survey settlement operation, the rent has already been fixed, and the Jamabandi has been opened in their name, that is annexure. B series of my affidavit dated 29 2024. B September 2024. वो मेरा affidavit filed
Thank
हुआ
you. WPC number 4254 of 2017. The learned counsel for the parties are present. The counsel for the petitioner and the counsel for the respondent, private respondent, For the state,
Yes, state, madam. There
the
is no
Learned
private, there
Council
is no
for the
private.
state has submitted that the present writ petition has become infructuous
Yes.
for all practical purposes, inasmuch as an affidavit has been filed dated 29/2024 annexing the rent receipts,
Jamabandi?
Jamabandi and rent receipt also.
No.
Okay.
Annexure A is the
Annexing
Khatyan,
the-
Annexure B is the Jamabandi. Now it is for them to get the rent receipt.
Annexing the Khatian and Jamabandi
Yes.
as Annexure B series, and it is now for the petitioner to approach whom the circle
They
officer.
can get the rent receipt from the Pragya Kendra also because online server also can.
It is for the petitioner to take appropriate steps for issuance of rent receipt. The Learned Council submits that the rent receipt can be also issued online.
Yes.
क्या बोलना?
नहीं, I am praying for new note to do it. I could not go through the file. I am sorry, Lord sir. आज note today कर दिया जाए.
कल
हाँ कल बिल्कुल कल रख दिया जाए. कल रख दिया जाए.
Counsel for the petitioner submits that he could not go through the affidavit dated 29/2024 and he prays for adjournment postponed.
Yes, all right. Lord sir.
Item 10, WPC 185 of 2018.
In terms of the earlier order, my lord, filing an affidavit. And further, my lord, in this case, if your lordship sees the last order, the learned advocate can also address your lordships in this case, my lord. He is otherwise busy today, my lord, I was praying for note today accommodation for the day.
Plus, they could have informed me yesterday when they had served the supplementary counter affidavit to me yesterday on email. They could have said that Melod's learned advocate general will not be able. Melod's, let me address Melod's this point.
Let us see what is the matter. आप पहले क्यों नहीं बताते हैं? उनको पहले ही
But
अपॉइंटमेंट
I yesterday evening I had gone to brief the advocate general. After I came to know that he is otherwise busy.
इसी जितना वो बिजी है उससे ज्यादा पिटिशनर का काउंसिल बिजी, राइट? उनको तो कोर्ट में कम काम है और इम्पोर्टेंट काम. भाई उनका तो एक मैटर चलेगा तो पूरा दिन चलेगा ना, कंटेस्टेड मैटर का. अब पिटिशनर का काउंसिल, जूनियर काउंसिल को एक कोर्ट से दूसरा कोर्ट दौड़ना होता है, राइट? बताइए थोड़ा सुन लेते हैं.
Melod's, the issue, Melod's, in this writ petition is whether remission under clause 13 of the HT agreement can be granted in respect of demand charges as well.
Issue is settled.
It is settled, Melod's. It is settled by line of precedence, Melod's.
क्या बोल रहे
We
हैं?
said that today the affidavit of your lordship sees, my lord. We said that the question of remission would have come when we would have demanded demand charges. We have never heard the bill of demand charges.
Melod's, that issue is also settled, Melod's.
Issue is also settled.
Even if there is no AMG bill, even if there is no demand,
Yeah,
then also,
441.
Melod's.
Therefore,
आपको तो ऐसा काम दिया.
the learned advocate never wanted to address your lordship.
इसीलिए.
Yes.
क्योंकि you are in the back foot.
We were aware of this, that this submission would come, madam, and he is ready also. Let it be on the reopening week, madam.
Learned counsel for the parties are present. The learned counsel for the respondent submits that Mr. Rajiv Ranjan, the learned advocate general, has been engaged by the respondents to argue this case
Your
on
lordship
their
may say
behalf.
your lordship may say the chief law officer. JUVN is the chief law officer. AG come,
कोई Advocate General
Come,
come Chief
Chief
Law
Law
Officer has been engaged to argue this case on behalf of the respondents, and today he is not available to argue this case. Counsel for the petitioner has opposed the prayer for adjournment by submitting that by virtue of order dated 14th of September 2024, the matter was specifically fixed for today on the same ground, and no advance notice of adjournment was given to the petitioner. Correct? बताइए, choose your date.
Reopening week any day.
Monday 14 तारीख. Let this matter be, however, since the respondent
Can you get 15th?
respondent is seeking time, pose this case on 15th. of October 2024 to be taken up at 2:50 as first case under the heading for final disposal. Now judgment advancement. It is made clear that no further adjournment will be granted, and if the chief law officer is not available on that day, the counsel appearing on behalf of the respondent in the court who is on record shall advance his arguments. दो डेट हो गया काफी.
Item 11, WPC 2522 of 2020.
Withdrawal in this case, being IA number 10886.
Simplicity of withdrawal.
Since it is become infructuous.
The learned counsel for the parties are present. IA number 10886 of 2024 has been filed by the petitioner, seeking withdrawal of this petition by stating that the case has become infructuous. Counsel for the respondents have no objection to the prayer made. Considering the submissions, this petition is dismissed as withdrawn. I give close.
Much obliged.
इसमें है लगा.
Item 12, WBC 4030 of 2020.
Yes, petitioner.
Has been redressed, madam. It was with respect to the issuance of the rent receipt of the
WBC
Jamabandi.
number 4030 of 2020. Counsel for the parties are present. This petition has been filed for the following relief. The learned counsel for the petitioner submits that the grievance of the petitioner has been redressed and therefore he does not want to press this petition. He does not want to pursue this petition. Counsel for the respondents has no objection to the prayer made and seeks permission to withdraw. Accordingly, this petition is dismissed as withdrawn.
Signed.
Under super withdrawn is concerned, madam, because they have already received also issued. On that point, it is being clear. So the matter has been settled.
We have stated in our counter affidavit that the rent receipt has
That's
already been
right.
issued.
He doesn't want to press it. Withdrawn. आपका submission तो लिखा दिया इन contracts में.
Item 13, WBC 4082 of 2020.
Yes, petitioner.
Plus, in this case, I have today I accept I received Kalkama after no objection.
You have an appellate remedy. This is you have challenged the notice.
Notice.
Yes. What happened thereafter? This is a
Plus-
matter of 2020. Is there any stay by this court?
No minutes.
Then you did not
Plus,
participate.
in the suit, decreed in my favor regarding the land in question. Thereafter, the CCL preferred appeal, which was entertained. Later on, this honorable court set aside the appellate order, and now on 30th of this month, 20th of September, they preferred SLP before the Honorable Supreme Court. They have said in the counter, that's only. So, so
If you
far.
want, now you want it released. Now this particular release.
Yes,
right?
Mr.
This notice has become infructuous for all purposes. Because now there is a title suit with regard to the same property.
Even then, they have issued, they have disconnected my water connection, my electricity connection, both. They have disconnected. I want to file interlocutory application.
What interlocutory application?
Because knowing well,
You see,
the
we are
title
only-
has been declared in my
We are
favor.
only concerned with the relief that you have sought.
Yes, Mr.
Right?
Yes, ma'am.
Your relief is that you have challenged the notice. Now there is a
Madam.
title suit in connection with the same property.
That
and
has
the
been
matter is
decreed,
pending, that has been ultimately decreed in whose favor?
My favor.
In your favor.
Yes,
So
madam.
there is no question of this. They will not. If the matter has been decided by virtue of title suit in your favor,
My
then there is no question they will proceed with this.
They are proceeding, my lords.
We
They
will
have
we'll
decided.
observe this. We'll observe this.
Yes, madam.
Right.
My lord, in this case, Mr. M.B. Lal is the counsel, my lord, and he is not because some puja is there in the house, so he just.
2:15 बजे बोलिए कोर्ट बंद नहीं हुआ है. Right? Ask him to be here. Unnecessary these cases are pending.
My lord, yes, yes.
Call him. 2:15 बजे तक पूजा हो जाएगा
My
ना?
lord, my lord.
बुलाइए.
अब ले. Plus, in the meantime, I may be permitted to file this वकालतनामा.
उसी समय कर देंगे या फाइल कर दीजिए. ये वकालतनामा. Infructuous cases को खत्म करने का है ना. Unnecessary a burden, right?
Item 14, WPC 4401 of 2020.
In this case, my lord, we have filed an earlier application for extension of time to file counter petition.
How much
In
time?
fact, 4 weeks, my lord, we have prayed only. On 28/8/2024, my lord, there will be the action.
When is 4 weeks expiring?
Today is 3rd, my lord, that will be 3rd of November.
3rd of November. 3rd of November would be a holiday.
Thereafter, immediately.
So you file it by 11th
Lots.
or maybe 12th. 11th is opening by
That will
12th.
do.
You can file the rejoinder by what time?
Within a week.
Within a week. So 12th is his day. You file it by 19th. Okay? And then we can post it on 3rd of December.
Lots.
Well, I have filed one IA for substitution and the information to this court, as well as I have filed the wakalatnama on behalf of the legal aids.
That is the
That is 9047.
There is a substitution petition. IA number?
IA number 9047. Petition number 1820.
When did the petitioner expire? On 23/11/20.
Yes, 23/8/2020. Affidavit of residency. It has been filed on the same. It has been filed on 24/8/2024. I am having the reason.
Oh, this just a moment. This is 24/8.
Yes.
You have filed this IA.
Mine.
Who has expired? Petitioner
Petition
number?
number 18, 20, 25, 35 and 38. I am mentioning para name of the
Petitioner
legal
number
aid.
18,
20,
20,
25,
25,
35
35,
and 38.
38. Right? What is the date of expiry? Date of death बताइए.
Yes. 18 filed on 23rd of November 2020.
This is for 18.
Yes.
23/11/20. And
20, serial number 20 died on 14/1/2024.
serial number?
20. RS6.
21. 21 is Vijay Kashyap.
No, 20.
20. Serial
Page number 21. Page number 21. Vijay Kashyap.
Yes.
He died on, he is petitioner
He is
number?
25.
He is 25. He died on 11/11/2020. 11/2020. Right?
Yes.
Then
Then petition number 25.
petitioner number 25. No. Then there is Chamra
35.
Orang.
35.
Chamra Orang.
No, my lord, 25, my lord. In my submission.
It has already been recorded.
Chamra Orang.
Chamra Aura 35. Petition number 35.
35. He died on
19/11/23.
11/23.
And then petition number 38.
Petitioner number
38.
38. His
9
name
of
is
21.
Jaga Orang.
Yes.
Yes.
Jaga Orang. He is 19/4/2021 and petition number 20 बताइए. Petition number 20. 4 ही इसमें बोल हैं.
Petition number 20 is at serial para number 6 my lord on 14/1/24.
14/1/24. Where is the death certificate?
That is annexure 2 to this IE. As it is appearing my lord from the IE application.
Annexure 2. Okay. Annexure 2 is 11/11/20. What is the name of petitioner number 20?
It has been mentioned in para 6 as Ralho Urao.
It's not matching. Just a moment. देखिए petitioner number 18 का नाम है विजय कश्यप.
Lordship.
He has died on 11/11/20.
23/11/20.
Oh sorry, 23/11/20.
Yes.
Right? Death certificate है.
वो annexure 1 series है.
एक पेज नंबर 21 इसको जरा चेक करते हैं. Annexure 1 series में 23/11/20 it is Etwa Kashyap.
Yes.
Right?
Yes.
Petitioner number 18.
My lord.
Okay. Then you have नाम बता रहे हैं आपके.
एतवा उराव alias एतवा कच्छप लिख रहे हैं.
अभी रुक जाइए थोड़ा. पेज नंबर 21 में विजय कश्यप.
How does the
11/11/20. ये विजय कश्यप इस petitioner number 25. Right? Petitioner ठीक है 25 हो गया विजय कश्यप. उसका चमड़ा ओराउं petitioner number 35.
Yes.
19/11/23. Then Jaga Orang, petitioner number 38, 19/4/21. Petitioner number 20 का death certificate का.
Just a minute. I have had it. My lord, we have mentioned, my lord.
Mention से नहीं होगा सर. जमीन का लड़ाई है ना, एकदम exact होना चाहिए.
You mentioned in para 6, my lord. It has been
Mention
applied,
you want
but
a death certificate. बिना death certificate के कोई substitution नहीं होगा.
I will file the certificate.
और दूसरी बात, this petition was filed before this court on 21/12/20. जिसका भी डेथ उसके पहले हुआ है, उसका substitution allow नहीं होगा.
Death person.
जिसका भी सब petition है, जिसका भी डेथ 21/12/20 के पहले हुआ, उसका substitution हम allow नहीं.
ये तो November 20 में भी डेथ हुआ.
हाँ वही तो 23/11/20, 11/11/20, petition number 18 and 25 का सवाल ही नहीं उठता substitution allow करने.
How the वकालतनामा has been.
My lord, there is a judgment of this one also.
What?
That in the writ petition, limit is
Sorry?
in
The case has been filed on behalf of a dead person.
No, my lord.
Yes.
No.
23/11/20 is the date of death. Petition number 18.
And the writ
Petition
was
number
filed-
25.
Just a minute.
11/11/20 is the date of death. Writ
I will-
petition has been filed on 21/12/2020. इसीलिए हम इतना कहानी आपसे पूछे.
Oh, I'm sorry, my lord. I could not understand that. I will verify, my lord.
No, you verify it right away. 5 मिनट में आप देखिए.
Just a minute.
इसमें आपको देखने में कोई गड़बड़ होना ही नहीं चाहिए. एफिडेविट किसका है?
हम देख लेते हैं. एक मिनट.
संजय कुमार खुजूर.
Petition number 8. और जितने भी इसमें पिटिशनर है ना, सबका आधार कार्ड फाइल कर दीजिए. सबका आधार कार्ड चाहिए हमको. वो तो आपको करना ही पड़ेगा, लेकिन जो those persons who had died prior to filing of the writ petition,
I will verify.
you just verify it right away. देखिए 5 मिनट में देख के बताइए. डेट ऑफ एग्जीक्यूशन और वकालतनामा भी चेक कर लीजिए.
Item 15, WPC 162 of 2021.
Yes, petitioner.
It's Mr. Umesh Prasad Singh, is available to this.
What is the matter about?
This is related to BPLE proceeding. So BPLE proceeding was initiated upon the royalty land lands, and thereafter notice has been given for us to leave that land. Eviction notice has been passed, so that is under challenge.
BPLE proceeding.
Yes.
Right. The final order of eviction has been passed.
Yes.
Did you participate?
We did participate.
You have an appellate remedy.
There's this a title suit is also pending.
Title suit is pending, fair enough. But there is an appellate remedy under BPLE proceeding.
Yes, there is not.
So why
the same Khata mandates, then my neighbors had also come before this honorable court. Their application has also been decided by this honorable court that I have annexed with the supplementary affidavit. That's the order which has been passed.
Supplementary affidavit dated?
That's dated.
The proceeding has been quashed?
That proceeding has been quashed.
This is
Stating it to be a summary proceeding.
Who has filed the title suit? The state or
No,
you?
we have only filed the title suit.
Where is that order?
It is at page number 7 of the supplementary affidavit matters.
Dated?
It is dated 26th of July 24.
So
rejoinder to counter affidavit filed on behalf of the petitioner.
Para number 18. Can you read para number 18?
One of the arguments of the learned counsel for the respondent is that the present writ petition is not maintainable since the petitioner has already filed an appeal before the respondent number 3. In reply to this said argument, learned counsel for the petitioner has submitted that an application for withdrawal of the appeal has been filed. However, since the said respondent is not holding the courts, the same could not be withdrawn.
You have also filed appeal?
No, we have not filed.
What is the source of your title?
Well, it's sale deed structure. There are various sale deeds, and it is a long-standing Jamabandi being continued on it. My lords, it's a royalty land lordship, and we have purchased.
This order has attained finality. Yes, madam. This order has become final. इसका जरा check करिए. This WPC 3596 of 2020. Status check करिए इसका.
Lastly, direct check, no appeal was filed.
3596 of 2020. You have filed your suit?
Yes, ma'am.
What is the suit number and what is the stage of the suit? And when did you file it? And who are the parties in the suit?
State is the party.
Where is your suit?
I'm just
Allowed on 6 months place. March 29/3/2023.
नहीं इसका स्टेटस नहीं पूछ रहे इसका कोई अपील फाइल हुआ suit number?
I'm just
203 of 2020.
Pending before? Title suit? Title suit number 20?
203 of
203 of
2020. Pending before? Pending before when? And let us see the impugned order. You must have informed the authority that you have filed a suit.
Yes,
Still he has passed the order of
yes,
litigation.
they are appearing in the appeal.
No. No, let us see the impugned order here.
It is annexation 9, it's page number 244.
Page number 244. Sir, it is preceded by some order. It is a follow-up notice. Where is the order passed by the BPLE order? Where is that order?
The
Order is annexation 2.
suit number 203 of 2020. I before the civilian senior division.
Dhanbad. Ranchi.
Paragraph 18. Paragraph 18 of the return.
Para
Sir,
18.
please, under section 80, but one thing you can kindly see, same land was subject matter of the consideration to the coordinate land, and they filed the house and academic report before the court, and when this matter was heard on 31st of January 2024, a specific direction was given to the secretary to file academic. Now they have filed academic that only a notification under section 4 of the Erstwhile Land Acquisition Act 1890 proposing to acquire under section 4.2. So that notification was issued to everyone than this. So this remains a private land, and I think the
Just a moment. Just a moment. Section. Just a moment.
And in that case also, your legislative will find reference of this case also. And one thing is very serious. In this case, the order passed by the Honorable immediately. Earlier when I had argued this matter on 9th of November 2020, it was given as to them. When your was related to decided on 9th January 2020. But when he approached the circle officer, he said he had already passed the order on 6th itself.
Where is that order?
Same order was passed by the coordinator. CWJC number WPC number 3596 of 2020.
The court has held that it is an antedated order.
No. What had happened, Malas, that we had earlier approached this honorable court, Malas, and challenged the notice, Malas. The court gave us liberty to appear, and the final order was to be given by the authority, Malas. The order is of 9th of November, Malas. When we approached the authority, this order dated 6th of November was handed over to us, stating that the final order has already been passed.
Where is annexure 1 page number?
Malas 49, page number 49.
I think we require judgment copy here.
Page number 49 is the earlier one.
Yes.
You filed a petition 2621.
Yes.
Right? Pursuant to the notice, you were directed to appear.
Yes. Para 8, what you will see on page number 15.
Same in that case.
This was filed on 9th of
This
November.
order is of 9th of November, Malas.
Okay. And where is the fresh order passed?
This is the order, Malas. Page number 52, Malas, annexure 2 is the order.
Page number 52.
Yes, Malas. This is
He
of
says on 6th of
November, my lords. That is before passing the theory.
Paragraph 11(6). In paragraph 7 of the judgment, kindly see. Other submitted to petitioner also. Nina Singh of
This is arising out of a different encroachment case. This is encroachment case number 1 of 2021. This is encroachment case number 3 of 2021.
The manage the khata number, the plots are all nearby, lordship, and our name is also been
Khata
mentioned.
number, plot number are also not the same.
Manage our details are also mentioned in that order, manage.
Plot number 1492, divisional survey, khata number there. They are not given there. What is the survey number?
Where is your allegation that it is antedated? Para number 16?
Yes, manage.
Any counter affidavit was filed in the earlier writ petition?
It was disposed of in the first.
On the very first day.
I think after they made a plan, the direction, but on 31st of January 2024, filed the documents. And now the state filed the document. A notification under section 4 of the Land Acquisition Act dated 9/10/1983.
And what is the date of your purchase?
But there is subsequent that
Page number 25
So, can any purchase be done after issuance of notification under section 4?
there was your basic right. But they proposed to acquire it under section 4. But
After the issuance of notification under section 4, is it legally permissible for the parties to enter into sale deeds?
because it was only intended
I think after issuance of notification, subject to what you have to say. After issuance of notification under section 4,
now that
no sale deed can be executed.
after the new Acquisition Act will be deemed to be a non-existing act.
Where is your sale deed?
Well, it's on page number 25. We have given the details. Lordship.
I want to see your sale deed.
Yes, ma'am.
Only section 4 proposed notification.
The sale deeds are from page number 80. Lordship will see there's mutation receipts. Thereafter, the sale deeds are there.
Technically, we are in possession of the land.
That's right.
But structure
Merely
are
because that is you are in possession, that is not sufficient. A notification under section 4 has been issued prior to your purchase.
That is in 1983.
That's right.
But note that was abandoned. That notification came to an end because further action was not followed. Possession was never taken under section 9. No section 6 notification. Section 6 notification is issued, then it will be a bar. Because that question is that acquisition is complete, possession only is taken.
Yes, it was only a proposal. No, it was only a proposal.
No, I will not, I can't follow that order just like that. There is a clear-cut notification under section 4. We have to decide what is the impact of that notification. We will decide.
Notification is the counter affidavit of the
That's right. That's right. We have to decide that what is the impact of notification under section 4 and whether any sale deed could have been instituted.
And that also be
And apart from that, whether this order is backdated or not is something which we have made a very serious allegation, isn't it? So that allegation has to be tested. Where is your record? Where is your original record in connection with the encroachment case? Because there is an allegation that you have backdated. Where is your original record?
It's not.
You produce the original record. The allegation of backdating is a very serious allegation.
Paragraph 16 we have stated.
Yes, yes.
Not even
We are asking them to produce the original record to find out if there is any backdating. ठीक है, उसमें notice का date होगा, appearance का date होगा. There may be many things. There could be certain orders by which the dates are being fixed for the purposes of hearing. File देख के तो backdating पता लगता है, right? Counsel for the
एक thing has taken at these honorable courts or earlier order, what was the statement of the state that it is still pending on 9/11.
we will see. We will call for the records and see. We'll conduct the inquiry ourselves.
On 3 days, we had already been when we approached them, they said on 6 itself, they said, and it said 1 million.
You see, now it has come on record that there was a section 4 notification. Let us see the file and figure out. What do you have to say on section 4 notification? Was it taken to a logical end?
This petition will come only when under section 9 petition is fixed.
That's right.
Section 9, kindly see section 6 and section 9 of the legislative old treaty.
Yes, therefore this has to be decided. It is not a simple case that I can just say that it is covered by that judgment. It has to be decided what is the impact of section 4 notification. It cannot be just quashed like that. And as it is, a suit has been filed.
Now yet on
You have filed a written statement in the suit? Or that is closed?
Subject to decision of the civil court will be decided. Question of title can be decided. After 70 years, a encroachment proceeding initiated against the person. Private
We have to adjudicate the allegation of backdating. We can't keep it open. When there is a very allegation of backdating is a very serious allegation for anybody.
For that, prima facie to prove that, I request you kindly see the paragraph 5.
We will ask. We will. See, we want to see the records. There should not be any problem about it, isn't
No,
it?
I have no problem. I definitely have no problem.
What is the date of notification and section?
Paragraph 1 is say, I will find it. The honorable judge, that matter is substitution. If he has found so far so well there, and then we have sent back again.
It's written in Hindi in November 1983.
What is the date of your purchase?
We have purchased in 2010.
WPC number 162 of 2021. In paragraph 16 of the petition, a serious allegation of backdating has been made in connection with the order passed by the concerned officer in encroachment case number 3 of 2020-21, which was said to have been passed on 6/11/2022. Prior to the order passed by this court in the earlier round of this application, in WPC number 2621 of 2021, dated 9/11/2020. The learned counsel for the it has also transpired during the course of hearing that a notification under section 4 of the Land Acquisition Act was issued as back as on 9/10/1983 in connection with the properties involved in the present case, and the sale deed by virtue of which the petitioner is claiming title and possession over the property is of the year 2010. It has also been reported that one title suit number 203 of 2020 has been filed by the petitioner in connection with the properties involved in the present case. The plaint of the title suit kahan lagana has been annexed at
It's Annexure 7, page 217.
at Annexure 7 to the writ petition. The title suit is original suit number 203 of 2020, which is said to be pending before the Court of Civil Judge, Senior Division, 1st Dhanbad, seeking declaration of right title interest and confirmation of possession. The learned counsel for the state is directed to produce the original records in connection with encroachment case number 3 of 2021. Office is directed to call for the present status of the original site title suit number 203 of 2020 along with a copy of the entire order sheet. Let this order be communicated.
That the Jamabandi area under section 68 of the report B, Total Transport Pendency Act, Jamabandi is as a force of pendency, you IDP, cannot be declared to be trespasser or intrusion.
We are not going to declare anything. We just want to know the entire status of the cases.
Now evidence is Jamabandi.
We are just asking them to produce the records. We'll decide whether it is backdated or not. पूरा रिकॉर्ड चाहिए हमको अटेंडेंस जो फाइल होता है उसके साथ ठीक है एक भी डॉक्यूमेंट हटा लिएगा मत उसमें कब रख दे बताइए पोस्ट दिस केस ऑन 16th October okay 23rd October the original records we handed over to the learned court master on 21st of October.
In the meantime, interim order may not be allowed.
There is an interim order in your favor, expiring today.
It was on last 2 dates he could not appear. So we have taken only passover for the day also. So on those dates it was
Till 23rd of October 24, the interim order passed earlier shall continue. Let this order be communicated through fax to the concerned. इनका appearance दे दीजिए ऑनलाइन लिखिए through BC senior advocate and should be the counsel. Have you seen?
Yes. Also, case item 14.
Affidavit on 20/10/2020. It is recorded in the court record. It has been filed on 21/12/2020, but office notice is there on 21/12/2020. One day office note cannot be done, madam. It has been filed. Office record, court record says it has been filed on 21st of December 2020. Then this number cannot come.
Which number cannot come?
First, and office note is
Which
there.
number cannot come?
Means 4,400. The read petition number is 4,401.
Yes.
And
ये जरा डेटा इसका जरा वो निकालिए.
हम दिखाते हैं उसमें.
21/12/2020.
ऑफिस नोट में है 21/12 को ऑफिस नोट भी हो गया उसी दिन.
नहीं हो सकता है क्या?
No, madam. It has been registrar signed is of 24/12, whereas the office note is of 21/12.
ये 4401 of 2020. We will go by the date of filing. We will not go by the date of affidavit. We will go by the date of filing. On the date when the case was filed, he was not.
Yes, I also accept that
So you have to
court
delete his
record
name.
is the
We will
authentic
not-
proof.
we will not-
But my lord, one thing, there is defect removed, defect pointed out that is of the same day.
It is not impossible. They have the matter was plain. We will not dispute that it was filed on 21/12/2020.
I'm not disputing. I'm, but on the
If
same.
you are not disputing the date.
No, my lord, I can show one thing, that defect has been pointed out on the same day. And
There is
it
no legal bar that it can't be pointed out. Is there any legal bar? There is no legal bar. Yes. It is not a case where the defect has been pointed out prior to the date of filing. No. It is a case where the defect has been pointed out on the same date on which it has been filed. The date of filing is the sheet. The date of filing is 21/12/2020. On that day, 2 of the petitioners had expired. We will not permit his substitution. We will not permit. You can challenge this order if you want to, but we will not permit. वो जो होता है ना date of filing, क्या क्या petition filing हुआ, वो चलो.
स्टेटस में है, स्टेटस में वो 24
जो है
21
बस
बार
हमारा रिकॉर्ड ही हम चलेंगे, हम अपने रिकॉर्ड से चलेंगे, आपके रिकॉर्ड से तो नहीं चल सकते ना।
Well, the second page of the read petition may be seen, back side.
हाँ ठीक है।
That will clarify. I am not disputing what is mentioned in the very first page of the orders, but at the same time, I feel that
So
within a week the defect has not been removed. Dated is 21/12/2020.
So
I have seen that the date of filing is shown in the status report is 21/12/2020.
we will not dispute our records.
I am not disputing because it is
It
court
was
record.
filed on a day when the petitioner had already expired. We will not accept it.
And my lord,
So far as these two persons are concerned, petitioner number 18 and 25, their name is required to be deleted. We delete it. We are not saying anything more. Affidavit करा के अपने पास रखे रहिएगा तो यही होगा। कौन सा महीना में affidavit कराए हैं?
10वां महीना।
10वां महीना में, और 2 महीना तक रखे रह गए भाई, और ये हो गया। Who is to be blamed for that? भैया आज एफिडेविट करा लीजिए, 2 साल बाद फाइल करिए, कोई मनाही थोड़ी है, नहीं है ना? लेकिन हम लोग तो डेटा फाइलिंग से ही देखेंगे।
Naturally, I am not disputing the court record, but at the same time, I know office note is there of the same date. File is to move from one place to another place. No?
Mr. Mehta, your practice is much more than my practice in Jharkhand.
I'm sorry.
Right? There is no legal bar in conducting stamp reporting on the same day. It is not an impossibility. Right? He has done it, he has given a date also. The date of filing is recorded in the computer. The moment you present it at the counter, it is instituted as per the previous procedure. Right? There may be many cases filed on the same day after this case number. Isn't it? There are so many records in the High Court to support that the case was filed on the day when it is showing in the computer. 24 तारीख 23 तारीख तक कोर्ट खुला था, राइट?
But मान लो 6000 केस फाइल हुआ तो 2000 तो ये 3 दिन में नहीं हुआ होगा। ये इसका 4401 है, तो 6000
सर
केस फाइल
आपको हम समझा नहीं सकेंगे, अब मेरा ऑर्डर आपको समझाएगा। देखिए WPC नंबर 4401 of 2020। So far as ये पिटीशन नंबर 20 का डेथ सर्टिफिकेट रिकॉर्ड पर नहीं है।
Yes. उसके लिए हम पार्ट 6 में लिखे हैं कि it has been applied, it has not been received.
आपको लाना पड़ेगा डेथ सर्टिफिकेट के बिना कुछ नहीं होगा, और हर एक पिटीशनर का आपको आधार कार्ड फाइल करना पड़ेगा।
दे दिया,
सबका लगा हुआ है
जी।
ऑल द पिटीशनर्स
नहीं, उसका मांगवा देंगे,
उसका भी मंगाइए। लिखिए IA नंबर 10841 of 24 in WPC number 4401 of 2020. Counsel for the petitioner submits that petitioner number 18, 20, 25, 35 and 38 have expired. However, from the records of this case, the death certificate of petitioner number 20 has not been placed on record with the intermediary application. So far as petition number 18 and 25 are concerned, their date of death is 23/11/2020 and 11/11/2020, as per the death certificate enclosed with the intermediary application. The records of the case reveal that the case was filed on 21/12/2020, though the petition was affidavitted on 20/10/2020. It appears that this court is of the considered view that the case having been filed on 21/12/2020, and by that time the petitioner number 18 and 25 had already expired, and therefore the substitution so far as petitioner number 18 and 25 are concerned, the same cannot be allowed. Accordingly, the prayer for substitution with respect to petition number 18 and 25 is hereby dismissed. Office is directed to delete the name of petitioner number 18 and 25 from the cause title. At this, counsel for the petitioner has submitted that the death certificate of petitioner number 20 shall be filed by way of supplementary affidavit. Let it be done. It is further directed that the petitioner shall file the Aadhaar card, a copy of the Aadhaar card duly certified to be true copy of the original Aadhaar card of each of the writ petitioners in the present case. The same be also filed. The affidavits be filed by 16th of October. और ज़्यादा टाइम चाहिए? By 23rd of October. और ज़्यादा टाइम चाहिए?
How much time?
आपको कितना टाइम चाहिए सबका आधार कार्ड फाइल करने? 23rd October. 23rd October. Post on 24th in the supplementary clause list.
Well, for the legal heirs of these person who died, I have given the.
अच्छा आपको तो आइए भी था ना, like आइए भी ना, just a file thing, just a petition, a petition seeking time, extension of time has been filed, being IA number 10841 of 2024. IA number check कर लेंगे, है ना? Accordingly, time till 12th of November is granted to the respondents, respondent number 1 and 2, to file the counter affidavit. Rejoinder, if any, by 26th, post on 3rd of December.
Okay. That's all.
Mr. Rupesh Singh आ गए हैं? बताइए लागी है
Also case item 3, the PC 508/2016.
Next case, my lord, CS 16.
Yes, what do you want?
My lord, I am assisting this honorable court, my lord, but the assistants, my lord, Bhavan Prasad, has been sought with gun injury on Friday evening. So, and another counsel, my lord, on advocate on record, Arvind, is also in Paras hospital.
When do you want?
Any day subject to my lord's convenience.
आप चूज करिए ना,
ठीक हो जाएंगे, लगता
बुलेट
है।
इंजरी हुई है,
बुलेट इंजरी पीठ में है, हो सकता है 1 दिन 10 दिन में ठीक हो जाए। आप छुट्टी के बाद कोई दिन रख दीजिए।
23rd
मतलब
क्या मैटर है?
मैटर ये है मतलब कि हम लीज रिन्यूअल के लिए एप्लीकेशन दिए
खास में है?
खास
क्या हुआ, रिन्यू कर दिया?
और रिन्यूअल होने के पहले ही जो प्रोसेस चल रहा है, हमारा नापी हुआ है, सब हुआ, तब तक ये सब दूसरे लोग को इंटरवेनर्स बिफोर लॉर्डशिप दे आर गोइंग टू सेटल। उसी पे हमने अमेंडमेंट फाइल करके उसको भी चैलेंज किया है।
आपका
कैंसिल आज तक नहीं किया है,
एक्सपायर हो गया है।
हाँ, वो एक्सपायर।
They say it is their property, we say that it is our property. We have
But it is a
from
खास
the
माल लैंड, we are
खास माल land.
प्रॉपर्टी हो ही नहीं सकता जब तक हमारा लीज
खास
कैंसिल
लैंड का कहानी जो सरकार इतना दिन से कर रही है, ये कहानी कभी खत्म होगा? Stories are never going to end. कुछ तो पॉलिसी भी नहीं लाते हैं आप। इस खास में को परमानेंटली सेटल कर दीजिए, चाहे कुछ कर दीजिए। आया तो है कुछ।
पॉलिसी एक लगाए हैं, and the entire action of the state is against their own policy.
Who is for the intervener in this case?
I'm
for the
respondent.
My young friend is
on this personal ground of medical ground.
Yes, I have already
With the
informed
consent,
you.
serial number 16 indicated. With the consent of the learned counsel for the parties, post this case on 23rd of
Much.
Password case item 3, the RBC 5781 of 2016, along with item 4 to 7.
You're just given the outline,
Right.
but you can argue your case in your own mind.
What I could understand from the list of judgments given by the respondents, but may I first deal with their contention, then I'll place my
No, you
note.
place your case.
Yes.
We were just hearing them to find out that what are the contours of the case.
Right.
You argue your case in your own mind.
But I'll be relying upon certain judgments of the extracts which I have taken for my lord's kind reference. The liquefied petroleum gas order 2000 and the essential commodities act 1955. Lord, I have brought the copies for the honorable court. Presume, my lord, I have given my copy of essential commodities at basis for my lord's I had
Why
noticed.
have you taken out just extracts?
But these,
We will read only that portion of the judgment.
my lord, these are the settled principles of law, my lord, which I will be relying upon.
For the purposes of challenging the validity of the
Yes,
clause?
yes.
Let us see. What do you want to say? You argue your case.
Yes.
You argue your case on the point of validity first.
Essential commodities that I copy of this case.
हाँ है तो आपने
I
दिया
have given two copies.
ये वापस करना ठीक बताइए
Well, these petitioners are the dealers of the liquefied petroleum gas. And my lord, under the agreement, there is a clause that I'll abide by all their guidelines, regulations, orders, rules for my lord, observing the marketing disciplines. My lord, different paragraphs have been numbered in the different agreements. In some of the agreement, it is paragraph 23. In some,
कोई
it is
चार्ट होगा
paragraph.
इसके साथ एक चार्ट है हाँ चला Yes, we have got that chart.
Now, my lord, the judgments which are being relied upon by the respondents with respect to the Delhi High Court order, my lord, in appeal, the Karnataka High Court order also in appeal, my lord, I beg to submit, my lord, that there was one issue which was never before the honorable courts, and that is, my lord, that the contention of, my lord, the respondents that the MDG has been upheld, my lord, that order of the Honorable Division Bench of Delhi High Court and Karnataka High Court are somewhat on the different grounds. In the sense, my lord, Delhi High Court, while upholding the MDG, has drawn its reference from the clause of faithful performance from the agreement. My lord, to that extent, my lord, it has a persuasive value. But the Karnataka High Court, my lord, while dealing with this, has held that persons who don't have that faithful performance clause in their agreement, they will not be bound to observe these, my lord, guidelines issued by them. My lord, the other, my lord, aspect which was never raised before those honorable high courts.
No, I just want to know that the clause which was subject matter of consideration before Honorable Delhi was similarly worded as that of yours, or it is different? Faithful
There may be
clause
slight
is-
difference, my lord,
but
not a
by
major
and large
difference.
it is the same.
By and large, because
So-
that was for motor spirit and high-speed diesel, I am LPG.
That's it. So therefore the clauses are similar.
Right.
The clause which was there before the Honorable Karnataka High Court was also similar.
Right.
But those who do not have that clause in their agreement, they did not follow.
They need.
So we are not concerned with that.
No.
In all the cases, you have that clause.
Yes. Now, my lord, submission before my lord is that in those two cases before Honorable Delhi High Court and Honorable Karnataka High Court, this aspect of the matter was never, my lord, submitted by the petitioners, nor, my lord, it was a subject matter of consideration. That the, my lord, punishment which is prescribed in the MDG guidelines is, my lord, fine. Now, fine, that too, my lord, not by way of recovery through any judicial process. It's an expropriatory confiscatory aspect of the MDG. My lord, this Honorable Supreme Court, my lord, way back, may I indicate, my lord, from my list of. Yes.
Have they imposed fine on you?
Yes, my lord, they have imposed fine. If my lord may kindly see page 3 of my compilation of my lord extracts of the judgments. My lord, the Honorable Supreme Court in the case of S.A.L. Narayan Rao, that is on page 3, versus Iswarlal Bhagwan Das, 1965 SEC online, page 18. My lord, the Honorable Supreme Court defined what is civil proceeding and what a criminal proceeding. The expression, may I place, my lord, the relevant paras. The expression civil proceeding is not defined in the Constitution nor in the General Clauses Act. The expression in our judgment covers all proceedings in which a party asserts that the existence of a civil right conferred by the civil law or by statute and claims relief for breach thereof. A criminal proceeding, on the other hand, is ordinarily one in which, if carried to its conclusion, it may result in imposition of sentences such as death, imprisonment, fine, forfeiture of property. The character of the proceeding in our judgment depends upon the nature of the tribunal which is invested with the authority to grant relief, not upon the nature of the tribunal which is invested with the authority to grant relief, but upon the nature of the right violated and the appropriate relief which may be claimed. A civil proceeding is therefore one in which a person seeks to enforce by appropriate relief the alleged infringement of his civil rights against another person or the state, and which, if claim is proved, would result in declaration, express or implied, of the right claim and relief such as payment of debt, damages, compensation, delivery of specific property, enforcement of personal rights, determination of status, etc. Here, my lord, when this judgment is to be read along with, my lord, the second judgment at page 2, that is, my lord, Khemka and Company versus State of Maharashtra, para 39. On a consideration of the provisions mentioned above, it seems to me to be clear that whatever may be the object of levying a penalty, its imposition gives rise to a substantive liability which can be viewed either as an additional tax or as fine for the infringement of law. The machinery for procedure for realization comes into operation after its imposition. In any case, it is an imposition of pecuniary liability which is comparable to a punishment for commission of an offence. It is well settled canon of construction of statutes that neither a pecuniary liability can be imposed nor an offence created by mere implication. It may be debatable whether a particular procedure provision creates a substantive right or liability, but I do not think that the imposition of pecuniary liability, which takes the form of a penalty or fine for breach of legal obligation, can be relegated to the region of mere procedure and machinery for realization of tax. It is more than that. Such liabilities must be created by clear, unambiguous and express enactment. My lord, I emphasize the term enactment. The language should leave no serious doubts about its effect, so that the persons who are to be subjected to such liability for infringement of law are not left in a state of uncertainty as to what their duties or liabilities are. This is an essential requirement of a good government of laws. It is implied in the constitutional mandate found in Article 265 of the Constitution that no tax shall be levied or collected except by authority of law. My lord, it was dealing with the jurisprudence of tax law. But my lord, what I draw from these two judgments, my lord, that the imposition of penalty by way of fine is a criminal imposition of punishment. And my lord, if at all accepting the argument of the respondents that it arises and relates back to the clause of faithful performance in the agreement, and the MDG is protected by that clause of clause 42 or 23, whichever it be, my lord, the respondents, by way of their marketing discipline guidelines, does not have the power to impose fine which is in the nature of a criminal punishment.
So your first point is that fine is invariably a criminal act.
A criminal
criminal.
punishment
Only
for an
only
offence.
through the criminal jurisprudence you can impose fine. This
Can
is
be
your
imposed.
first argument.
This is the first.
The second argument is that there has to be an express enactment to impose a criminal liability.
Might.
No, my lord, just a moment, I'll just capture it. The counsel for the petitioner has submitted that the marketing guidelines which are under challenge has power to impose fine. Clause bata dijiye. Power to impose fine on account of non-compliance of the guidelines. He has referred to the judgment passed by the Honorable Supreme Court, reported in AIR 1965 SC 1818, SAL Narayan Rao versus Ishwar Lal Bhagwan Das, and also the judgment passed by Honorable Supreme Court in the case of Khemka and Company within bracket Agencies Private Limited versus State of Maharashtra, reported in 1975, Volume 2, SSC 22, to submit that the imposition of fine can only be through a criminal liability, and in absence of any express provision to impose fine through any act, the marketing guideline could not have provided for imposition of fine. The learned counsel submits that in all these cases, fine has been imposed upon the petitioners for the violation of marketing guideline by virtue of the guidelines themselves and not backed by any enactment.
Additionally, my lord, to further fortress this submission, my lord, the dispute between the parties is of civil in nature. It arises from a contractual aspect, as being sought to be derived by them through the faithful performance clause of the agreement. So, my lord, in the proceedings which are culminating into the imposition of fine, the proceedings are of civil in nature. My lord, allegation of breach by one party or the other, but the imposition is of, my lord, a punishment which is, my lord, specific to the criminal jurisprudence.
So, if there is a breach, the agreement should have been terminated instead of imposing
They
fines.
could have done. They could have done so.
You are happy with that?
It is up to them. If
No,
they
no.
want to close their
No,
business,
we will-
not, it is up to them.
We do not know whether they want to close their business. You want to close your businesses or not is a matter of concern.
Provided I am held to be, my lord, found to be guilty of the, my lord,
We
breaches
do not.
alleged against me.
You see, if you say that the fine cannot be imposed, fine in terms of economics is a lesser punishment than termination.
I agree. But then
So you want me to hold that only termination was permissible?
but they have their recourses in the agreement also, what actions they could take. And there are, my lord, parliamentary enactments which provides for, my lord, punishment for violation of these, my lord, retail outlets. So there are, my lord, laws which govern if we commit any, my lord, error or a fault in, my lord, carrying out our obligations.
The learned counsel for the petitioner submits that the matter is essentially arising out of a contract between the parties, and it is and should have a civil consequences. And consequences of violation of the agreement and terms of contract has already been provided in the agreement, but fine which can be imposed only through which can only be a criminal liability could not have been imposed. During the course of argument, he has submitted that. Aage
My lord, the provision of imposition of fine, my lord, in the 2001 MDG guidelines, that is, my lord, Annexure 7 to the writ petitions, and my lord, in 2015, that is, my lord, WPC 5781 of 16, my lord, this came after the 2015 MDG guidelines. The punishment, my lord, of imposition of fine is in clause 3.2.
No, whatever be the
Clause 3.
clause, in the guidelines there is a provision.
There is a provision of imposition of fine.
So you have to give me the exact clause of each of the guidelines. You give me the exact clause.
My lord, 2015 guidelines, my lord, will take clause 3 of the guidelines.
2015 guidelines.
Clause 3. That provides for imposition of fine.
Okay.
And in 2001,
2001.
my lord, there is no clause as such. They have prescribed by way of a chart indicating the, my lord, breaches and the punishment indicated there. That, my lord, is at Annexure 7 to WPC 3952 of 11 at page 73. So this is a very small guidelines at that point of time containing of only
3952 of 11. Page?
Page 73 and Annexure 7.
These are the two guidelines.
These are the two guidelines.
The Learned Counsel submits that the clause regarding imposition of fine is at clause 3 of 2015 guideline, and so far as 2001 guideline is concerned, it only prescribes a chart with breaches and consequences.
Right.
He submits that 2001 guideline is at page number 73, at Annexure 7, page 73 of WPC number 3952 of 2000.
Additionally, in 2001 guideline, there is no prescription of any appeal in the guidelines.
The Learned Counsel submits that so far as WPC, so far as 2001 guideline is concerned, there is no provision of appeal. There is an arbitration clause
In the agreement.
in the agreement,
In the agreement.
though there is an arbitration clause. But so far as 2015 guideline is concerned, there is a provision of appeal
Right.
as well as an arbitration clause.
And the arbitration clause in 2001, my lord, in the agreement of previous writ petitions, my lord, they are in-house arbitration arrangements, my lord, that the officer themselves will operate as an arbitrator. We don't have the provision of having an independent arbitrator.
So that section 11 is there.
Now, my lord, proceeding further, my lord, in the
Let us see the clause 3 of 2015. This is 2016. The allegation is of which year? It must be after 2015.
My lord, two writ petitions, one is of 2014 and one is of 2016. Rest 3 of them are of 2011. So 4 of them are guided by 2001 MDG guidelines and one is guided by 2015 guidelines.
Now let us see the clause 2016. You say this is clause number 3.
Yes, my lord, I had filed a supplementary affidavit bringing that on the court. Sworn on in November 2017. That is, my lord, filed on 31/10/17. In WPC 5781 of 16, supplementary filed on 31/10/17.
So it is the clause number 3 which is under challenge in this proceedings.
My lord, the challenge is basically to the, my lord, power assert onto themselves with respect to imposition of penalties in the nature of fine. They may have, my lord, clauses to regulate, to ensure, my lord, that the marketing disciplines are, my lord, prescribed and observed. But, my lord, the punishments which they have, my lord, taken onto themselves to impose, that, my lord, is the very, my lord, the crux of the matter with which the petitioners are aggrieved of. Because it is in the nature of expropriatory confiscatory nature. I, my lord, deposit my security deposits before the companies. They are in possession of it. They allege something. I dispute, I make certain submissions. They come to a conclusion without any personal hearing. And from my security deposit, the amount is deducted.
You were never heard?
No,
you were never granted any hearing?
No. A so-called notice, a reply, and then the order of penalty.
That is enough?
My lord, that depends, my lord, if, my lord, the so-called notices, if they contain, my lord, evidences with respect to certain customers making allegations and the documents are not provided. Here, my lord, will find, my lord, the guidelines itself provides, my lord, is seeing the supplementary affidavit, my lord, may kindly see page 24.
Process of imposition of action.
Yes, clause 3.6, the last line. The so cause notice should be issued along with all reports and other documents, etc., which forms the basis
This
of
is on natural justice. That is a separate thing altogether.
No, they are harping upon it that they are not required to furnish the documents upon the basis of which the so cause is issued.
That is a separate link. Now you first conclude your argument so far as the validity of this marketing guideline is concerned.
So far as the validity
And
means.
you have in your writ petition you have where is the challenge to this marketing guideline?
My lord is having WPC 5781.
I have 578.
Yes. In the prayer portion itself, my lord, first para, for passing of the orders of reference so and so, then my lord, para C, passing the marketing discipline guidelines 2015 for LPG issued by Ministry of Petroleum and Natural Gas, Government of India, containing proposed penalties for major minor irregularities by LPG distributors, as the guidelines are arbitrary without jurisdiction and the teeth of settled principles by the Honorable Supreme Court of India, as the penalty proposed to be levied under the said guidelines does not contain any provision for mandatory opportunity of personal hearing to the affected persons before taking any action, no procedure for determining the fault of the irregularities prescribed therein, and the said guidelines does not contain any provision of appeal either against the action taken under the impugned guidelines to the agreed persons against such preemptive action in the nature of quasi-penal charge and punishment there being bad in law.
And where is your where is the show cause and the reply?
Yes, my lord. The show cause lawyers will find. That is annexure 2, page 51. I'll be, my lord, indicating the malafide on their part in issuing the so cause from their own document in the counter affidavit.
Where is your reply?
But my reply is next to that annexure 3. I had taken certain grounds, my lord, denying the charges, and then the order of penalty at page 57.
आपने तो बोला है कि उपरोक्त उत्तर को एक्सेप्ट कर लिया जाए. You have not even asked for the person. You have said that उपरोक्त उत्तर से संतुष्ट होंगे एवं मेरे उठाए गए प्रश्नों का उत्तर देने का कष्ट है.
But they proceeded to impose the penalty. Why not accepting it?
In the show cause,
My lords have seen this so cause, and my lord, in their own counter affidavit, I would be permitted to indicate certain, my lord, aspects that why this so cause is a malafide so cause.
counter affidavit से show cause थोड़ी improve हो जाए.
No, they are malafide aspect in the so cause because there was no deficiency as such indicated which are, my lord, reflected in the so cause. The inspection report. No, my lord, the charges itself are not supported by their inspection report. My lord, the so cause refers to an inspection on 27/5/16 in the first line. If my lord may kindly see the counter affidavit filed by them.
They have filed the inspection report.
Yes, they have filed the inspection report. Page 13, my lord. has my lord come to that.
Yes.
My lord, this is my lord will find the inspection report with respect to it. There is in bracket showroom on the top within the my lord, rectangular column.
In page 13.
Page 13, Annexure A to the counter affidavit by 2 and 7, 2 to 7.
Annexure 8.
Annexure A, page 13.
Annexure 8, yeah.
The counter by
You
respondent.
have filed supplementary affidavit.
My lord, I
And
am
you have
indicating.
brought on record the inspection report.
Yes, my lord, I am relying upon their own counter.
No, I just want to know that this inspection report you have filed through supplementary affidavit.
Yes. And then same inspection is also being brought by them on record by their counter.
Just a minute. जो आपके ऊपर अनलॉफुल ग्रेटिफिकेशन की बात करें ना तो उसको आपको एसीबी को खबर कर देना चाहिए. It's very difficult to find out. You are making an allegation that he was asking for some bribe
That
in
is
the
very
petition.
My lord, this my lord, aspect of biasness by the field officer will be reflected from their counter itself by the inspection report and the so-called notice issued upon us.
Please tell us, what do you want to say?
My lord, Annexure A, page 13 of their counter affidavit.
Page 13. Yes.
My lord, at the top, my lord, Indian distribution inspection report within bracket showroom. Then, my lord, on the left side, inspection dated 27/5/2016 as indicated in the so-calls. My lord, this goes with a chart finding, my lords, what are the deficiencies and discrepancies in them, and if my lord will kindly come to page 15.
Yes.
Now, my lord, what is indicated finally after the inspection is in showroom backdrop of Indian not found, hot plate not found displayed, glow signboard not found displayed, showroom staff were not in uniform, distributors backlog is 1637 opening on 27/5/16 but no indent placed on 27/5/16 till 1300 hours. Now, this I must clarify that there were, my lord, bookings by the consumers amounting to 1637 refills being sought, but by 1300 hours I had not requested and placed the indent upon the company. That is what is indicated. Then 6, no manual register found placed on point number 9E. Showroom is totally non-standard. Agreement papers not found available in showroom. Advised to keep copy in showroom. Do not disclose do not close counter after lunch as from 28/5/16 onwards. This is one aspect, my lord, with respect to the showroom. And the next page, my lord, starts with respect to inspection of the godown. Same date of inspection, 27/5/16. And my lord, after going through, my lord, these inspection reports, my lords will find at page 18 signature of all the parties, my lord, the distributor and the company representative. But then from page 19 onwards, they enclose, my lord, certain customer response sheets.
Yes, sir.
Now, by reliance upon these customer response sheets, Lord, they tend to, Lord, justify their action as proposed in the so-called notice. that there were certain discrepancies. My lord, if these customer response sheets were there when the inspection was carried out, my lord, the endorsement in the in the inspection report never speaks of these aspects. And all of a sudden, my lord, the show cause notice
Is
says
it signed by you?
it has been signed by me.
But so how do you dispute it?
My lord, my submission to that extent is that these customer response sheets are taken by the field officers, got signed on the blank, and then they fill it just to coerce us to come to their terms. This is, my lord, the exercise being undertaken by the respondents.
Why did you sign it? How does your signature figure on this?
My lord, because there is a saying, my lord, पानी में रह के मगर से बैर नहीं कर सकते. I have to comply. If they ask for me to put a signature on the blank papers, I have to put it.
कहीं पे भी sign कर देंगे. And you will deny the signature completely.
No, my lord, this is further fortified. Because
Anybody can put the signature and deny it completely.
Lord, if these are, my lord, taken to be genuine and bona fide documents of the respondents, why did the respondent did not indicate, my lord, I put a question to myself, in their inspection report that these are the aspects which are, my lord, staring at me. The inspection report, closer report, my lord, that at the last page of the
You explained
showroom.
your signature on the document. Have you explained it?
Yes, my lord, in my reply, I have explained it.
But you have not stated that you were made to sign on blank sheets or
But
ऐसा कुछ है नहीं और इस तरह का इंक्वायरी हम लोग रिट में नहीं कर सकते.
No, I'm asking.
Right.
I'm not asking
Please
for an inquiry.
don't.
I'm only
You are trying to
impress.
include malafide.
I'm trying to impress.
So who is the person who has been made by name to respond to your malafide, or the entire company is like that?
My lord, in most of the
Have you
petition-
made anybody as party
Yes,
responding
my
by
lord.
name?
In 3952, my lord, the field officer is party by name.
He has
Eugene Sirki.
responded?
He has not entered appearance.
That's right.
He has not entered appearance. His, my lord, his malafide conduct was that when he used to visit our offices, my lord, the godowns and the showroom, he was running
Did
a...
you lodge any complaint before higher authority at any point of time
Yes, my lord.
against
was-
that officer?
Yes, my lord. To the higher authorities of the company, that is
When?
part of the writ petition.
When?
My lord, with the reply of the so-called.
No, that is a separate thing. You see, he was a regular harassing person, isn't
Yes.
it? Did you ever file any complaint against him before the higher authority?
My lord, that I couldn't...
After the inspection, you can file many complaints. Before the inspection.
My lord, had it been a solemn occasion, my lord, one can understand, my lord. If every, my lord,
That's
distributor
it,
in the area has a similar grievance against the field officer, asking for illegal gratification either by cash or by kind, that is one aspect.
That is all.
No, my lord. I need to submit, my lord. My lord, in the case of Gulf One Hotels Limited versus Union of India 2014 10 SEC 673, the first page of the, my lord, extract of judgments which I have provided. That is 2014 SEC 10 SEC 673. Dealing with, my lord, the Honorable Supreme Court dealing with the question what is law, has perplexed many a jurisprudence, yet the search for elusive definition continues. It may be unwise to posit an answer to the question. Rather, one may proceed by examining the points of consensus in jurisprudential theories. What appears to be common to all these theories is the notion that law must possess a certain form, contain a clear mandate, explicit command, which may be prescriptive, permissive, or penal, and the law must also seek to achieve a clearly identifiable purpose. While the form itself or absence thereof will not be determinative, and its impact has to be considered as a lending or supporting force, the disclosure of a clear mandate and purpose is indispensable. My lord, the mandate I will be, my lord, emphasizing upon it. Then, my lord, para 19 of the judgment, Article 77 of the Constitution provides that the form in which executive must make and authenticate its orders and decisions. Clause 1 of Article 77 provides that all executive action of the government must be expressed to be taken in the name of President. The celebrated author H.M. Sirvai in Constitution of Law 4th edition, Accordance, Volume 2, 1999, describes the consequences of government orders or instructions not being in accordance with clauses 1 or 2 of Article 77 by opining that the same would deprive the orders of the immunity conferred by the aforesaid clauses, and they may be open to challenge on the ground that they have not been made by or under the authority of the President, in which case the burden would be on the government to show that they were in fact so made, In the present case, the said burden has not been discharged in any manner whatsoever. The decision in Air India Cabin Crew Association versus Yasaswini Merchant, reported in so-and-so, taking a somewhat different view, can perhaps be explained by the fact that in the said case, the impugned directions contained in the government letter, not expressed in the name of President, was in exercise of statutory power under Section 34 of the Air Corporations Act 1953. In the present case, the impugned guidelines have not been issued under any existing statute. In the absence of due authentication and promulgation of guidelines, the contents thereof cannot be treated as an order of government and would really represent an expression of opinion. In law, the said guidelines and their binding effect would be no more than what was expressed by this court in State of Uttaranchal versus Sunil Kumar Vyas in the following paragraph of the report. It is settled law that all executive actions of the Government of India and the Government of State are required to be taken in the name of President or Governor of the state concerned, as the case may be. Orders and other instruments made and executed in the name of President or Governor of a state, as the case may be, are required to be authenticated in the manner specified in the rules made by the President or the Governor, as the case may be. In other words,
so far as the state is concerned, they may be state for the purposes of Article 12. Otherwise, they are not state. For the purposes of Article 12, yes, they are state. But otherwise, they are not state. They are a separate legal entity having a seal. They are a company, a government company. So this judgment with regard to as to how the state authority has to function will not apply.
I'll draw, my lord, an inference from this judgment that admitting, my lord, they are a state under Article 12 of the Constitution. My lord, all the more reason that they don't have the mandate to act as to their requirements to fulfill their, my lord, aims and objectives by short-circuiting the process of law. If, my lord, the enactment by the Parliament is covering the field, the respondents cannot have their own say, coming out with certain guidelines and having unto themselves the my lord, power to punish with imposition of fine. So, my lord, if the state or the union cannot do something unless compliance of Article 77 and my lord, 166 is carried out, my lord, the corporations are all the more barred from acting in the, my lord, manner contrary to those provisions and articles of the Constitution. My lord, para 24 says it will not be necessary to notice the long line of decisions reiterating the aforesaid view. So far as the mode of publication is concerned, it is consistently held by this court that such mode must be prescribed by the statute. In the event the statute does not contain any prescription, and even under subordinate legislation.
These are the points which were there is already a decision regarding the power of issuance of guideline, etc. That decision is already there. But you were trying to distinguish those cases by saying that in this case, the power of imposition of fine has been is under challenge, and according to you, it is a penal action, and therefore they could not have done it. But so far as the other aspects of the guideline, the source of power, etc., there is a judicial pronouncement.
That has a persuasive value, my lord. But the judicial pronouncement of Delhi High Court and Karnataka High Court.
You are not in a position to show me any striking distinguishing feature to take a different.
My lord, these aspects which I am submitting for kind consideration, my lord, these were never before the Honorable High Court. My lord, may I only persuade, my lord, subject to what my lords will conclude, and finally, my lord, we have to go down to that. But for my lord's kind my lord, consideration, my submission is that either before the Honorable Delhi High Court or before the Honorable my lord, Karnataka High Court, the my lord, source from which it has been held to be, my lord, a valid guidelines, that is relatable to the clause of faithful performance of contract. But my lord, it was never a question raised before these honorable high courts that if the state or the union could not promulgate any law without following the articles of the Constitution, my lord, any undertaking under them.
Parties can contract anything.
My lord,
unless, you see, there are certain grounds, contractual obligations, rights and obligations, then mutual obligations fall on a very different footing as compared to the constitutional protection which has been granted to the citizens of India against the action of the state. You should not have, you see, there is a contractual obligation. That
submission is not that even under the contractual obligations, if one or other clause or a conduct or an action arising thereof is contrary to the law of land, my lord, that cannot be upheld.
We'll see that.
If it violates the, my lord, law of the land or is contrary to the constitution even, and a legal right is sought to be infringed, but that has to be tested whether it can be sustained or
Is
it
it your
cannot.
fundamental right to deal in dealership of LPG?
No, my lord, I don't have a fundamental right
So
to deal
therefore,
in.
when there is a contractual obligation arising out of such contract,
My lord.
what legal right are you talking about?
My lord, the legal right which arises from any contract, my lord, entered between two parties, that any clause which is, my lord, contrary to the law of land, that cannot be enforced.
That's all?
My lord, the other two issues, my lord, which I am raising is relying upon, my lord, the judgment of Honorable Supreme Court in Kranti Associates Private Limited, where, my lord, the Honorable Supreme Court has laid down 14, my lord, reasons why the order of a judicial, quasi-judicial or any body has to be a reasoned and speaking order. And, my lord, if the notices which are issued to be, my lord, answered by the affected party, if the notices itself indicate that they are with a prejudiced and closed mind, and that the person who is expected to respond to it knows from the language of the notice issued that he is to bang its head against a closed wall, Lord, that exercise of issuance of so-called notice to the other side is an empty formality of principles of natural justice. If the so-called notices are there, my lord, it has to be open-ended. It could not be, my lord, in the nature that they have already come to a conclusion that I have committed this wrong and now I am asked to respond, which, my lord, will find from the so-called notice of this petition itself.
They have found some material, they have put it across you. If they do not put the material, whatever is mentioned in the show cause across you, then you will say that there is no allegation in the show cause.
My lord, the so-called
They have found some material, they have recorded it in the show cause, and they want you to respond. How do you say it is a preconceived notion?
My lord, on two counts. The so-called notice indicates certain deficiencies and discrepancies on my end which are not reflected in the, my lord, inspection report. If the inspection report is being relied upon for issuance of the so-called notice, my lord, the inspection report has to be seen whether the...
Which allegation is not there in the...
Yes, my lord, we'll see page 51.
Yes, which allegation is not there in the inspection report? Tell us.
Allegation number 1, that is not there in the inspection report. Non-supply of refill by 3 customers.
No, this has been there in the show cause, in the inspection.
My lord, may kindly see the inspection report again.
Yes, they have annexed the inspection report.
Yes, they have annexed it. The discrepancies in their inspection report are reflected at the last page. Of the report, starting page 15 and ending at page...
You see, for taking care of these aspects of the matter, you have a remedy under. So we will not go into that. Okay. Now you tell us.
My lord, page 15 of their counter affidavit, the discrepancies which they have found and the so-cause which I have been served upon, they are incongruent. They have indicated 9 points to me at page 15. And my lord, point number 1, then point number 2, then point number 3, overcharging, point number 4. These are not reflected at page 15 of their inspection report. So this indicates not their malafide. I presume, my lord, that the signatures made by me on the, my lord, customer response sheet, even if for the sake of argument, my lord, if I admit them, that it was before me, my lord, what had prevented them to take note of it and indicate in the inspection report, which is being relied for issuance of the so-called notice? I put a question to myself, my lord, for the respondents to answer. And this MDG guidelines, my lord, the Honorable Delhi High Court as also the Honorable Karnataka High Court has traced it to the, my lord, source of faithful performance. My lord, I have a different answer to it. It is traceable to the Essential Commodities Maintenance Act and the LPG Order 2000. My lord, they may have argued before the Honorable High Court that it is traceable to the faithful performance of clause. But if my lords will kindly see the Essential Commodities Act and the LPG Order 2000, my lord, what does the MDG guidelines is intended at? It is intended at to ensure that the companies, parallel marketeers who are indulging in the my lord, sale of liquefied petroleum gas, they have to maintain a CRISIL rating. And for the purpose of rating, they have to my lord, have a marketing discipline guidelines so as to impress upon the investors that their money is safe and secure, they will not be falling under any trap.
Which section of Essential Commodities Act are you
Yes,
saying?
my lord. Essential Commodities Act, my lord, section 3, powers to control production, supply and distribution, etc. of essential commodities. And when, my lord, this is read with the LPG Order 2000, the opening line says, my lord, the Gazette notification, 26th April 2000. In exercise of powers conferred under section 3 of the Essential Commodities Act 1955, the central government hereby makes the following orders, namely, and this, my lord, prescribes what is to be adhered to by the oil manufacturing companies or their retailers and distributors. And, my lord, may kindly also further see Schedule 1 to this LPG order. It's a delegated legislation under the Essential Commodities Act, duly published in the Official Gazette. My lord, may kindly see Schedule 1 to this LPG Order 2000 at page 11, I presume. After the clauses are concluded, then comes the Schedule 1. Prohibited activities for government oil companies, prohibited activities for parallel marketeers. Then, my lord, may kindly turn to Schedule 4. And my lord, may be pleased to read it with clause 11 of the LPG order. What, my lord, clause 11 says? Assessment and certificate rating of parallel marketeers. And no parallel marketeer shall commence in any activity such as importing, storing, transporting, bottling such and such on the basis of its transportation, accident relief transportation, and attending to emergency complaints of consumers by an agency given in Schedule 4. Now, these agencies, as in Schedule 4, are required to, my lord, rate the OMCs, oil manufacturing companies. And while doing so, my lord, if my lord will further turn to Schedule 7 of the order. This is in relation to clause 11, subclause 4. Subclause 4 says the agencies given in Schedule 4 for the purpose of evaluation shall, on payment of fee by the parallel marketeer, evaluate the parallel marketeer whose case is either referred to it or who approaches it on the basis of parameters indicated and the information provided by such parallel marketeer in the format as specified in Schedule 7 or such other information as may be required by the rating agency. Now, when we see, my lord, Schedule 7 and point number 6 at relevant page 18 of Schedule 7. Has, my lord, come to that. Now, here, my lord, we find the term marketing discipline and guidelines proposed to be adopted. So, my lord, this MDG is related to be adopted from this. It is not, my lord, relatable to the faithful performance clause of the agreement. And, my lord, if I am successful, my lord, in convincing the Honorable Court that it cannot be related to the faithful performance agreement, my lord, then if it will fall under this, and if it falls under this, my lord, they cannot have unto themselves the power to impose fine upon us, which is a criminal liability. of an offence committed by us. And this, my lord, MDG guidelines to be adopted is for two purposes: code of conduct for distributors and deliverymen, and B, system to monitor and control adulteration and unauthorized diversion of products. So they have to, my lord, make a MDG guideline mechanism to comply these aspects. It is not indicated therein that they can have unto themselves the power to impose fine by issuance of a so-cause notice and imposition of a penalty without, my lord, having a personal opportunity of hearing, as is there in the Essential Commodities Act 1955, because it is, my lord, cognizable by a magistrate. I have a full, my lord, entitlement of full-fledged trial to put my defense, to get me heard in person before any fine is imposed upon me. So my submission is, my lord, that the findings of the Honorable Division Bench of Patna of the Honorable Delhi High Court and Honorable Karnataka High Court were never, my lord, informed by the assisting counsels with respect to existence of these conditions. And these conditions are, my lord, by the enactment of the Parliament and then, my lord, a subordinate delegated legislation duly published in the Gazette. My lord, these will always override, my lord, any other interpretation of having, my lord, resource from which they can derive their marketing discipline guidelines. Now, if they are deriving their guidelines under these provisions, my lord, they have to, my lord, abide by the conditions of the Parent Act, which is 1955 Act, and which provides for a, my lord, personal hearing and a summary trial to me before imposition of fine or even, my lord, sentence for imprisonment if I commit any violation. They may prescribe, my lord, conditions which I have to comply with, but when failure occurs, my lord, they have to fall back on the 1955 Act for taking any action against us under the MDG guidelines violations. Yes. Agreement, my lord, in this case was by another supplementary affidavit. I'm sorry, my lord, I'm just I think they have got it on. Yes, my lord, in the writ petition annexure 1, page 36. And the faithful performance clause, my lord, will find at page 43. The distributor undertakes faithfully and promptly to carry out, observe and perform all directions and orders or rules made from time to time by the corporation or its representative for proper carrying on of the distribution of the distributorship of the corporation. This does not entail, my lord, in any terms that a breach of these, my lord, will authorize them to impose the penalty of fine upon us.
Page number?
Page number 43 of the writ petition.
टाइट कॉपी ऐसे घुसा के डाली हुई है, पढ़ा ही नहीं जाता. Type copy is running into 6-7 pages for a 1 page, and the font size is 16.
We are helpless with the typists.
You should write your office, isn't it? The continuity of thought goes away, no, when you have to turn so many pages.
True, my lord. True. Running page 8 of the agreement.
Mark all the pages to read it.
third paragraph at page 8 of the agreement. That is clause number 23. If you count note from the previous page, it comes clause number 23. The distributor undertakes faithfully and promptly to carry out, observe and perform all directions and orders or rules made from time to time by the corporation or its representatives for the proper carrying on of the distributorship of the corporation. But this does not vest them the power to punish me.
You have the power to terminate. Fine क्यों लगाते? Terminate कर देना.
That would have been better.
That is better because he is arguing that here you have got the power to terminate, but you don't have the power to impose fine.
Although now it is said that this is lesser, this power we do not have, and the power to terminate is the harsher one.
No.
That power we have.
That is not my
This
submission.
is what we can hold.
This is
Yes.
not my submission. I don't say that this
The
power
power
did
to
not.
terminate is there on account of violation of any
Clauses
terms
of the
and
agreement.
conditions of
But
clauses.
power to impose fine, not they have to relate back to 1955 Act under the LPG Orders 2000.
If we see, the point is that if we say that the imposition of fine is bad in law, right? Then under
The
such
procedure is bad in
Just
law.
a moment.
I'm sorry.
Even if we say that the procedure is bad in law, even if we say that the imposition of fine is without jurisdiction,
Well,
the consequence of violation of one or the other clause has to be there.
my lord, that is there.
Termination is there.
That is there, my lord, under the agreement.
You are happy with that?
And my lord, the other provisions are there under the ESMA Act 1955 and the LPG orders.
So imposition of fine can be set aside, but the matter can be still left open for them to take appropriate order
As per the provisions of the
as
law.
per the provision of the Act, which includes termination of it.
As per the provisions of the agreement or my lord, the ESMA Act and the LPG Order 2000.
Which includes termination, because we have to say
Definitely,
that.
my lord, it includes termination. They can do so.
Then, under such circumstances, if there is any violation, there is no provision for just a minute. The display of the license or keeping the license or the required documents in your premises is required under the agreement, or it is also required under one of the other statutes?
But it is required under the MDG guidelines.
No, that is the guideline, because you are supposed to follow n number of acts.
Under the guidelines.
No, you see, page number, internal page 5,
Yes, ma'am.
there are so many acts which have
Obligations
been
upon
mentioned, right?
Yes, ma'am.
You have to follow the Petroleum Act, Payment of Wages Act,
All
Shops and
statutory
Establishment Act, Factories Act, Workmen's
Every
Compensation.
statutory compliance I have to
Every
carry.
statutory compliance you have to do, right?
And we do that.
I think under the Shops and Establishment Act, you are under an obligation to keep the licenses.
So there is a prosecution under the Act also.
There is a
In
prosecution
failure
under
thereof.
that also.
But if there are, my plain and simple submission is not if the law of land is there to cover all these aspects. But they cannot have a short circuit and run a parallel government of imposition of fine. It's like they are having a zamindari system here. They don't care of SMAC, they don't care of any other statutory enactments which I have to follow and observe. They have their own MDG guidelines and then they prescribe the punishment therein. And the imposition, my lord, fine, even under the Act of 1955, there is a summary trial before the magistrate. Here, a so cause notice, a reply, and then a punishment. No opportunity of personal hearing, neither, my lord, leading of any evidences to substantiate the rival claims of the parties. Lord, if this mode of imposition of fine is to be allowed by the companies, Lord, tomorrow they can impose any nature of penalty upon the distributors for one or other violation. They may come up with a revised guideline and they may even say, my lord, that in case of this breach you will be sentenced for imprisonment for 1 month because you fall under the faithful performance contract.
That's all?
Well,
Yes, what do you have to say?
Yes, only 2 minutes are there. The lecture may kindly see his whole argument is that MDG guidelines is only a guideline and it could not have been enforced and whatever, because there are certain laws which govern the field. Now, if I can show that, let us for a moment even take out the judgment passed by Honorable Delhi High Court, Karnataka High Court. If I can show that Honorable Supreme Court has affirmed these guidelines, then the entire matter ends here itself. Absolutely, Your Lordship may kindly take up the compilation which I have given. The last judgment, if Your Lordship would kindly take up, that judgment is 2019 volume 19 SCC, page 662, Indian Oil Corporation, and I have highlighted probably, Your Lordship,
Yes.
the important fact why the matter ultimately went to the Honorable Court. I am reading that. The challenge in the present appeal is to an order of the Division Bench of Guwahati High Court in so and so, maintaining an order of the Honorable Single Judge of the High Court, whereby the termination of dealership of respondent number 1 for violation of marketing discipline guidelines of 2012 was set aside. So, in that case, it was set aside. The matter reached the Honorable Supreme Court. Then, para 6, Your Lordship. On the basis of test reports dated so and so, the dealership was terminated. So, these are the facts. Then, Your Lordship may kindly turn to paragraph 9. The dealer challenged the termination of dealership before the Guwahati High Court. The learned single judge allowed the writ application on so and so, holding as per guidelines so and so. Then the matter went to division bench, which ultimately dismissed the LPA. Your Lordship may kindly turn to para 13. Here, 13 onwards, I am only reading the after 4 or 5 lines. It is further contended that in terms of clause 1.5 of the guideline, the motor spirit and high diesel so and so orders, the control order issued by the Government of India is applicable. The said order provides for a procedure of search and seizure. The search and seizure in terms of clause 7 of control order issued under section 3 of Essential Commodities Act can be effected only in the presence of 2 independent witnesses as is required under section 100 of the CRPC. Then the first para 14, the first issue required to be examined is as to whether the appellants were required to follow the procedure under the control order read with section 100 of the code. Then the Honorable Court answers after 5 lines. Therefore, we find that the effect of issuance of the control order is that in the event of violation of the control order, any person who contravenes any order made under section 3 of the Act, the control order, he is liable to be punished by a court. Therefore, the violation of the control order has penal consequences leading to a conviction. The provision of search and seizure as contained in clause 7 of read with section 100 of the code will come into play only in the event a person is sought to be prosecuted for violation of the provisions of control order. Admittedly, in the present case, the dealer is not sought to be prosecuted for the violation of the guideline. Therefore, the procedure for drawing samples, which is necessary precondition on the control order for prosecuting an offender, does not arise for consideration. The dealer, here the main consideration is there. The dealer has entered into an agreement on 2012-1995. It is not disputed that the dealer is bound by the guidelines issued by the public sector oil marketing companies. Clause so and so of the guidelines then it discusses. Then para 16 it says, the guidelines as mentioned in subclause 1 of clause 2.5 of the guideline is to streamline the functioning. That is, the oil companies should not be arbitrarily or without any justification send the sample for testing at their sweet will. And then para 18, Your Lordship, para 18 last 5 lines. In this case, since stock and variation was beyond the permissible limit and the sample failed, therefore the action was rightly taken under clause so and so of the guidelines. which is the critical irregularity when read with clause so and so of and subclause so and so of the guidelines, then just paragraph 20, para 19, your lordship may kindly turn, and just paragraph 20. The dealer was informed of the result of second test and was also given a show cause notice as to why the dealership should not be terminated. Therefore, the action taken against the dealer in terms of the guidelines as a consequence of the contractual obligation by the dealer, and therefore the order of the Honorable Single Judge and the Division Bench was set aside. So the Honorable Court clearly took note of the fact that it was contractual obligation and the guideline was a part of the contractual obligation between the parties. Now, strangely, my learned friend relies on another single bench judgment order passed by Honorable Karnataka High Court, but the
He has not placed it.
no, he was relying because he has mentioned in his pleading it also.
I was enlightened by my friend, he produced the appellate court order also. I was relying upon
Because
the
that
court order.
single judge order has been is there in his pleading, that has been set aside by Honorable
It has been
Division Bench.
modified.
So
It has been modified that if the clauses are there, the person is bound. If the clause of faithful performance is not there, he is not bound. That is what Karnataka High Court says. But this judgment, only one catch line is there, my lord.
I believe here, therefore, your lordship would take note of this recent judgment where the Honorable Court, the case was guided by marketing discipline guideline was taken into account, and the other connected laws which were there, despite that the Honorable Court held that because there was certain provisions were there in the marketing discipline guideline, those would prevail and the control order would not prevail in the circumstances.
So the penalty here is essentially a civil.
Why? Your lordship may kindly see the MDG guideline. Why this guideline is there? Now there are several categories. Your lordship may kindly take up the guideline. Guideline itself, Annexure 6, page 5. Annexure 6 of the
file along with the
supplementary.
supplementary.
They have annexed it in their supplementary affidavit. The revised marketing discipline guidelines of 2015 they have annexed. And your lordship may kindly see the first introduction itself. Liquefied LPG so and so marketing commenced in India in 1955, Bombay, Mumbai, and then so and so, so and so. Since then, the LPG market in India has evolved over the last 5 decades or more from a minuscule level to the present position of around 18.8 crore customers in the industry base. LPG marketing activities are expected to grow further because of the focus on expansion in rural areas. There is a network of over 16,500 LPG distributors in the country to meet the requirements of LPG consumers. LPG marketing is unique. LPG consumers are tied to LPG distributor with a very little freedom to choose their distributors. Such a vast and complex marketing activity requires proper discipline among the LPG distributors from whom the entire LPG customers are serviced. LPG distributorships are appointed by public sector oil marketing companies and are governed by the terms and conditions of the agreement entered between the OMCs and the distributors. The various clauses of the distributorship agreement spell out the several responsibilities that have to be performed by the distributorship as well as by the OMCs. Besides the responsibilities spelled out in the distributorship agreement, there are operating policies, procedures and practices that are required to be followed by the distributors to serve the LPG consumers. Further, there are prohibited activities that are to be avoided by the distributors. In order to ensure the distributors follow the operating policies, procedures and practices, various actions are taken against the erring distributors which are made, which are called marketing discipline guidelines. MDG form part and parcel of the instructions as issued from time to time and under relevant clause of faithful performance of the distributorship dealership agreement. These guidelines do not preclude any action on the distributorship agreement. And then MDG for LPG distributorship has been in existence for over 30 years. The first MDG was so and so, and these guidelines need to be constantly updated to meet the challenges of IT, the growing consumer expectation, ensuring the quality of the product and the services, enforcing discipline amongst the distributorship network, and to prevent malpractices in the sale of petroleum products. And so, therefore, what it ultimately...
I've got it. It has got a very wide impact
Yes.
on the public at large, and it is for a particular purpose,
And
special purpose.
there are three categories.
I just...
Those categories, your Lordship may kindly see, those categories are types of irregularities.
major,
page 11.
minor,
Page
critical.
11.
Yes, absolutely.
So, there are, first is absolutely major is critical irregularities. Then,
I want to see the clause by which penalty is introduced.
yes,
Yes.
it is there.
Where is that? I want
Yes.
to see that.
Page 24.
Page 24, process of imposition of action. Where is it exactly penalty mentioned?
Yes, it is there in, first is type of irregularity, and then action is taken in
Yes.
page 17, your Lordship.
And where is the penalty?
Yes, ma'am, that is prior to that. Penalty is prior to that.
Let us see the penalty in terms of money.
Yes, ma'am. Page 20, my lord, may kindly see.
Absolute critical is the first, but although it should have been first minor and then major and then critical, but it is there. Your Lordship may see the...
I want to know the
Input.
power to impose penalty.
It is there in page 18 also, your Lordship may see.
You show me
Major irregularities.
First instance.
Yes.
Minor
Fine of
irregularities.
equivalent to 20% of average so and so.
Page number?
Page 18.
18.
Major irregularity, clause 3.2. Fine equivalent to so and so. And then at second instance would be fine equivalent to, it would increase to 25%. And then at third instance it would be 35% and so on. Last and the major is, again, these are opportunities which are given to the distributor so that he does not indulge himself into these irregularities. So last and consequence is termination. Despite these, if he does not improve himself, and final is termination plus so and so to the consequence.
You see, this the quantum of fine is relatable to the quantum of loss.
Absolutely. And then your Lordship may also see the quantum of irregularity in
Yes,
case of...
that is why. Suppose there is an irregularity in connection with just one cylinder, then the quantum would be different. It is not a provision that irregularity in connection with one cylinder is put at par with irregularity in connection with 100 cylinders. The scale would be different, the quantum of fine would be different, and that is why it is also talking about irregularity, month of detection of irregularity plus quantum of irregularity. It is relatable to the quantum of irregularity.
So all these are facts which are now, your Lordship, whatever they are raising, these facts cannot be adjudicated in a writ proceeding, particularly in circumstances when there is absolutely nothing in pleading. They have, although my learned friend pointed out that it is there in inspection, but in
Not
our report,
supported by any.
no,
Straight
they
away
are
from the
absolutely,
annexures
they are
argued.
just showing it from the document itself.
That is, we don't accept such kind of
But
pleading.
then they were required to bring it in pleading also, that what were those things which they were disputing, and then only they could have done.
I hope we conclude.
5 minutes only take.
Post lunch.